Let's see if he's guilty first. If he's found guilty, then we find out if it's bad enough for the death penalty. Then if we find out it's good enough for the death penalty, then we see if they actually want to give him the death penalty. The defense has filed 14 motions against the death penalty. Let's go ahead and get started. Hey guys, this is Jules with True Crime Reactions. Disclaimer. Everything stated in this video is my opinion and my opinion only. And just like everything else in these cases we discuss here on this channel, everything is alleged. Okay, yeah, you heard right. 14 filings. Now, today was the deadline. Right now, it is 7:40 p.m. Today was the deadline for the defense to actually get any objections of the death penalty filed. Now, tomorrow, 9/6, which is most likely when this video is actually going to post, tomorrow, 9/6, is the state's deadline for the discovery. So I'm trying to get this one done now because I'm hoping that we do have a few things to go over this weekend. Okay, as you can see, we have 14 filings from the defense to strike the death penalty. Now, I posted earlier today this one right here because, like I mentioned, the state's discovery deadline is tomorrow, the 6th of September. This just basically giving like one little response, a little sealed response, okay, was posted earlier today and filed yesterday, 9/4. Honestly, sort of a waste of time considering that the deadline was 2 days after this was filed, but I guess they're just trying to like make sure as much paper trail as possible. I guess that's the only really thing that I could think of on that one. But then we had these. Okay, I left to go run an errand, came back and sat down, and boom, in my face. I was like, holy crap, I got home just in time. This is insane. I knew that they were going to be doing something. I've never gone through death penalty documents. I guess I wasn't expecting there to be so freaking many. But here we go. Let's get started with the first one, which is expert witness disclosure. This one is 54 pages long. Okay. This looks to be just information about the actual expert witnesses. It says, come now, Bryan C. Kohberger, by and through his attorney of record and pursuant to Idaho Criminal Rule 16, makes the following expert witness disclosures. Barbara C. Wolf, MD from Florida. Dr. Wolf is expected to testify to the findings outlined in her affidavit filed with the court on September 5th of 2024 in the defendant's motion to strike state's notice of intent to seek death penalty on grounds of vagueness in balancing aggravators and mitigators. I have no idea what that means. We gonna learn together today. Dr. Wolf's curriculum is also attached. And then Eliza Plinner Cover from the University of Idaho College of Law, a complete statement of all opinions to be expressed and the basis and reasons therefore are contained in Ms. Cover's law article, Narrowing Death Eligibility in Idaho, an empirical and constitutional analysis. And then, of course, her curriculum. Now, that's what all of this is. The remaining ginormous amount of pages, 54 pages, is just information about how much these two people are experts in this situation. I'm going to go all the way down. Now, that was all one person. How many pages is that? 44 pages are just the Wolf lady. That's cray-cray. Then the second person is the next, what is that, 11? 9 pages? Yeah, that's what that is. Okay, on to the second one. This is let's open it. 13 pages. I skimmed through this one earlier. This one, oh look, by the same person who got that strange, missed wording in the last video. If you didn't see this video right here, I did send an email right here. I went to the document, went to the emails that are on the back of the delivery sheet on the very bottom. I couldn't find one for Judge himself. I found one for somebody that works for Judge, but it was from back in 2022, and I don't know if it's still valid or not. I don't know. Who knows how they update things. So I emailed it to the people that were on the document itself and sent the link to their own thing. And I don't know. I'll let you guys know if they ever respond to me. But I did put in the email, a response is not expected, but appreciated. Anyway, let's get back to this. So this is the motion and memorandum in support of motion to trifurcate the proceedings and apply rules of evidence during the eligibility phase. Says, comes now Bryan C. Kohberger through his attorneys of record and hereby submits the following motion and memorandum in support of motion to trifurcate the proceedings and to apply the rules of evidence during eligibility phase. Proceedings with a bifurcated trial in which non-statutory aggravation is presented without the rules of evidence being applied will result in a violation of Mr. Kohberger's state and federal constitutional rights, including the 5th, 6th, 8th, and 14th Amendments to the United States Constitution, as well as Article 1, Sections 6 and 13 of the Idaho Constitution. Argument. Idaho's death penalty scheme provides for two phases, one where the culpability of the accused is determined, and then, if they are found guilty, a sentencing phase, commonly called the penalty phase. Problematically, at the penalty phase, the jury must actually make two determinations. These two determinations are whether the defendant is eligible for the death penalty, and two, what is the appropriate punishment. Okay, well, if the defendant is eligible for the death penalty and then something has to be decided, normally it's only being determined that the death penalty is appropriate because that is the appropriate punishment. I feel like those two things are sort of like, anyway. Under Idaho Code Section 19-25153B, a person is only eligible for the death penalty the jury finds beyond a reasonable doubt at least one statutory aggravating circumstance. If the jury determines that the defendant is eligible for the death penalty, then it must decide if it is the appropriate sentence. Well, that's kind of like the whole point of that. Okay. Where a statutory aggravator is found, the defendant shall be sentenced to death unless mitigating circumstances may be presented or found to be sufficiently compelling that the death penalty would be unjust. In order to sentence a defendant to death, both findings, eligibility, and appropriateness are required. Well, yeah, that makes sense. The jury shall not direct imposition of a sentence of death unless it unanimously finds at least one statutory aggravating circumstance and unanimously determines that the penalty of death should be imposed. Combining these two distinct determinations into one sentencing proceeding violates a defendant's state and federal constitutional rights. This has become increasingly clearer in recent years given the Supreme Court holdings in Apprendi versus New Jersey, and there's a million different sightings, and then there's Blakely versus Washington, and then Ring versus Arizona, which made clear that any factor that increases the permissible punishment must be found by the jury beyond a reasonable doubt. Well, isn't guilt in general? That's the rule of thumb for guilt in general. Under Idaho death penalty scheme, there are very specific statutory aggravating factors that make a defendant eligible for the death penalty. When determining eligibility, the jury must consider each statutory aggravator alleged and return a special verdict stating whether the statutory aggravating circumstances has been proven beyond a reasonable doubt. It is the state's burden to present evidence supporting each alleged aggravator. The Idaho Supreme Court has consistently held that the same facts cannot support more than one aggravator because it presumes that the legislature did not intend to duplicate aggravating circumstances. Then it cites State versus Dunlap, and then State versus Fain, and then State versus Card, State versus Osborne. It looks like they're all Florida cases. Therefore, trial court must instruct jurors that they are required to find independent evidence to support each statutory aggravator alleged. Even though the state must present very specific independent evidence supporting each aggravator, Idaho death penalty scheme allows the state to present general non-statutory aggravation evidence, and it cites State versus Hall, another Idaho case. Non-statutory aggravation evidence is aggravation that does not support any statutory aggravator. This evidence can only be considered by jury when determining whether the death penalty is the appropriate punishment, not when determining whether a statutory aggravator exists. If the statutory aggravating circumstance has been proven beyond a reasonable doubt, the jury then determines whether all mitigating circumstances, when weighed against the aggravating circumstance, are sufficiently compelling that the death penalty would be unjust. The trial in Hall exemplifies the difficulties created by this scheme. On the one hand, the legislature has indicated all relevant evidence may come in at the penalty phase. On the other hand, the legislature at the time had indicated that propensity to commit murder is to be shown by evidence of prior conduct or conduct in the commission of the crime at hand. There is no prior conduct, though. That's kind of like the problem here. That's one of the problems that the state has anyway, that there's not proof, at least so far, of prior conduct. Okay. By permitting evidence relevant to aggravation, but not to a statutory aggravator, the legislature has created a scenario where a jury's decision is necessarily confused. Donald M. Hauser outlined the potential problems in a law review article in which he analyzed the Federal Death Penalty Act, which, like Idaho's, is also a bifurcated system. He writes, "The jury hears all of the evidence of intent factors, statutory aggravating factors, non-statutory aggravating factors, and mitigating factors in a single proceeding before making these two determinations. Receiving all of this information in a unitary proceeding creates a problem because the jury's determination of whether the defendant is eligible for the death penalty may be influenced by irrelevant evidence. The jury may find the defendant eligible for the death penalty based on evidence that, even if established beyond a reasonable doubt, fails to satisfy the statutory requirements of death eligibility. The end result is that the issue of eligibility and punishment melt into a singular assessment." And then it says to see Donald M. Hauser, Reconciling Ring versus Arizona with the Current Structure of the Federal Capital Murder Trial, the Case of Trifurcation. It looks like it was done back in 2007. In this case, the state has alleged 5 different statutory aggravators. Mr. Kohberger anticipates that the state will attempt to introduce substantial evidence of aggravation, which is not related to any statutory aggravator, including evidence about Mr. Kohberger's past and evidence of Mr. Kohberger's character. Now that's interesting, but I want to read it again to make sure I'm understanding how this sentence is being presented. Okay. Mr. Kohberger anticipates that the state will attempt to introduce substantial evidence of aggravation, which is not related to any statutory aggravator, including evidence about Mr. Kohberger's past and evidence of Mr. Kohberger's character. See, like, I'm thinking about this in like 2 different ways here. Like, okay, first time I read it through just now, my mind automatically went to, that kind of sounds bad. That sounds like Bryan is very much aware that the state is very much in possession of something that can definitely be used against him, that he might actually know is coming. Because so far, what have they said? This whole time, Bryan and the defense team has stated they're going to use all of the state's evidence basically as a reverse Uno to make all of the evidence that's supposed to be working against Bryan actually work for Bryan in the end to exonerate him. Big word, big goals, big dreams. Okay. So that sentence right there threw me a bit, but then it says substantial evidence of aggravation, which is not related to any statutory aggravator, including evidence about Mr. Kohberger's past and character. So that does kind of tell me that maybe the state does have information. I mean, we as the public know certain things, right? Like, we've heard certain stories. We know about his past drug use. I have questions about that because regardless of the stories that we've gotten, it seems really odd to me that a 17-year-old would do something so cray-cray to the point to where they were addicted. That doesn't usually just happen. That's not normally what somebody so young just jumps into. So that is something that I've been super hella curious about, okay? So while it seems like the state is going to maybe present certain things about his character or past, it sounds like whatever it could be, the defense is under the assumption, according to what they know, that none of it is actually related to what's actually happening here. Now, a statutory aggravator is a negative factor defined by statute that can make a sentence more severe during sentencing meaning harm, injury, loss, or damage suffered by the victim, history of criminal or delinquent behavior, age of the victim, presence or hearing of certain individuals. So the fact that he was almost 30, old enough to know better, the fact that he has prior drug use, there's apparently a report of him stealing his sister's phone. There's been a couple of little things in his past. And then the fact that the injuries were so freaking severe, besides the fact they're no longer breathing, the way that everything is being described is horrific. But if Bryan is innocent, then none of those things have anything to do with Bryan. So I guess now I understand what they're trying to say. Okay, it goes on to say the state will also seek to introduce non statutory aggravation evidence in the form of victim impact evidence, like the fact that we've heard from the Goncalveses that they apparently have already advised their children to write their victim impact statements, which a lot of people find strange considering that we're still a year away from trial, if not longer. If not longer. To me, that's normally something that you write right before you give it because you're at the end of the journey and you're putting all of your thoughts together from beginning to end. And it's like your final FU to the person. You know what I mean? But I wonder if the defense only even knows that that's even a thing right now because the Goncalveses came out and said it publicly. Like they've said all kinds of other cray stuff. This non-statutory aggravation should be presented during a separate sentencing proceeding after the jury has considered the issue of eligibility based on the statutory aggravators. Under this construction, there would be a culpability phase, an eligibility phase, and a sentencing phase. Okay, so that's the try. That's the three. Now I understand. Okay, rather than just two phases of culpability and penalty. The jury would only be presented with non-statutory evidence during the sentencing phase and would therefore only be able to use it in its determination of whether a sentence of death is appropriate. I think I'm really understanding it here. Okay, so instead of the Goncalveses victims impact statements or anything of that caliber, okay, gets presented to the jury, they first have to determine if he's guilty. Like it can't be presented beforehand because it's part of the case about, these are the victims' families that are remaining and they should be able to have their word, their day in court. They should be able to get up and speak, right? They have the right to get up and give their statement. But this is accurate, and I figured this is just how it normally was. I didn't realize that you had to file for this. So there's cases where the victim's impact statements are read to the jury before the guy's even found guilty. Am I like assuming that correctly from understanding what's happening in this case? Because if that's really how this works, normally to where the victim's impact type stuff would be read prior to even knowing what the hell is going on or even determining if somebody's guilty or even death penalty eligible, that doesn't make sense to me. That sounds ass backwards and like a hella setup. Just saying. The consideration of non-statutory aggravation only for the purpose of determining whether the death penalty is an appropriate punishment is what is required by the statute. Trifurcating the proceedings is a way of ensuring that jurors are able to comply with the requirements of Idaho Code Section 192515 and consider the appropriate aggravator at the correct time. Non-statutory aggravating evidence is any evidence that is not directly related to proving one of the alleged statutory aggravating circumstances beyond a reasonable doubt. There are many types of non-statutory aggravating evidence that the state may choose to present, including victim impact evidence, as they stated. At sentencing, a quick glimpse of the victim's life may be given in the form of testimony about the victim's life, and it cites a case called Payne versus Tennessee. And then says, however, this quick glimpse has morphed into a full-length feature film in some cases. And then it cites a book, it looks like, from 2008 by somebody named Sharon Turlington. The expansion of victim impact evidence in the form of expanded victim testimony and video presentations for the jury has furthered the need for trifurcation. When jurors are emotionally overwhelmed by extensive victim impact evidence, they are likely to use the evidence and their grief for the victims in order to support. I'm not really quite sure which way that's supposed to go, but I just know that it's wrong. In addition to changes to the presentation, victim impact evidence, changes in the law in recent years have made trifurcation necessary and rendered bifurcated death penalty schemes unconstitutional. Constitutionally, the bifurcated model became especially problematic after the Supreme Court's holding in Ring versus Arizona. In Ring, the court held that statutory aggravators are elements of the offense of capital murder. Because Arizona's enumerated aggravating factors operate as the functional equivalent of an element of a great offense, the Sixth Amendment requires that they be found by a jury. Because statutory aggravators are elements of the crime of capital murder, they must be found by a jury. When statutory aggravators became elements, new constitutional problems arose. Factors once considered simply sentencing factors are now elements of the crime, and the bifurcated trial structure raises serious constitutional concerns. Evidence that a court would never admit at trial, such as victim impact statements, hearsay, and character evidence, is unquestionably permissible at the sentencing phase. However, during the jury's determination of a statutory aggravator, which is an element of the crime, the defendant is given none of the protections afforded the other elements of the crime adjudicated in the guilt phase. The eligibility phase is akin to a guilt phase in that the state bears the burden of presenting evidence supporting each statutory aggravator it seeks to prove. Statutory aggravation evidence should be treated the same way as other enhancement evidence permitted under other Idaho statutes. For example, when the state seeks to enhance a sentencing by alleging that a firearm was used in the commission of a crime, it presents evidence during the guilt phase in accordance with the rules of evidence. Similarly, when the state seeks to enhance a sentencing by alleging that a defendant is a perpetual law violator, like someone I know, it must present evidence during the guilt phase in accordance with the rules of evidence. I thought it cut to the next page because for some reason my eyes did not see that. When a defendant is charged as a persistent violator, pursuant to Idaho Code Section 19-2514, the jury determines whether he is persistent violator during a second proceeding. The jury determines whether he is a persistent violator during a second proceeding. The persistent violator charge is stated in a two-part information, State versus Johnson, another Idaho case. Initially, the jury is only informed of the offense with which the defendant is charged, part 1 of the information. Depending upon the verdict on part 1, the second part is read and the jury deliberates further. So initially, part 1 is just the actual offense itself. Okay, so just a guy broke into a Radio Shack and stole something, and that's the only case that gets heard in the very, very beginning in part 1. Okay, now here comes part 2. Depending on the verdict for part 1, okay? So when it comes to the sentencing phase, so say a person is found guilty of robbing the Radio Shack, okay? So here comes part 2 after the person has been found guilty. This is where they go back into the person's history. So if the person has robbed other places, has been arrested for theft before, has had maybe possession charges, has constantly been in trouble, has had several other run-ins with the law, that would then determine what the punishment is. So even if it's something simple, like stealing something for $50 out of a Radio Shack and running from the cops and getting arrested, now you're stupid. You got all these other things behind you. So instead of going to jail for maybe 2 years and being on probation for a few years, you're now in the pen for 10. That's what that means to me. When dealing with other enhancement statutes, judges have discretion to divide the proceedings into 2 phases. For example, Idaho law allows the judge to determine whether the firearm enhancement should be determined at 1 proceeding or 2. The court decides whether to give the firearm enhancement instruction along with instructions on the case in chief, or to allow the jury to deliberate on the case in chief first and on the firearm enhancement second, depending on the case. And then it cites State versus Stedfield, another one in Ohio. Idaho law contemplates judicial discretion and separation of the determinations when necessary. In this case, with the voluminous amount of non-statutory aggravation that is expected to be presented, separating the two determinations into an eligibility and sentencing phase is necessary to ensure a legal and fair sentencing. So to get clear on that, it states here that generally non-statutory aggravating evidence shows the impact of the crime on the victim's family or involves prior bad acts of the defendant. Well, in this case, it'll probably be both. It'll probably actually end up being both, and they're very aware of that. And again, what do they have that we know of publicly is stuff from a million years ago. Millions of years ago. And unless there's stuff that they've found since then that we just don't know about because of the gag order, it's a very weak argument as is. So, under the trifurcated model, only after the jury decides eligibility does it move on to the sentencing phase. In contrast to the eligibility phase, the sentencing phase, in which the jury decides whether the death penalty is appropriate, is more than a non-capital sentencing determination. At this phase, it is the defendant's burden to present mitigating evidence and the sentencer's role to decide the appropriate punishment. Unlike evidence of statutory aggravation, which must be proved beyond a reasonable doubt, mitigation does not need to meet this burden. The jury does not need to find that the mitigation outweighs the aggravation beyond a reasonable doubt. The jury considers both statutory and non-statutory aggravation when making this determination. The Idaho Supreme Court has held that the rules of evidence do not apply at capital sentencing proceedings. And then it cites Dunlap from Idaho. The court has held that the admission of evidence in capital sentencing proceedings is governed by Idaho Code 19-25156, which provides that the state and the defendant shall be entitled to present all relevant evidence in aggravation and mitigation. The Idaho Supreme Court has also held that the right to confrontation does not apply to sentencing procedures. The court explained, the justification for the refusal to completely extend the procedural protections of the Sixth Amendment to the sentencing phase is based, in part, on the belief that modern penological policies, which favor sentencing based on the maximum amount of information about the defendant, would be thwarted by restrictive procedural and evidentiary rules, and then cites Civic versus State, or it could be CIVAC versus State, and that's another one from Ohio, and then also they cite Williams versus New York. Under a bifurcated system, the bulk of evidence in capital sentencing trials is admitted without rules of evidence. And again, it says to see that 2008 book from that Turlington lady. Much of the non-statutory aggravating evidence the jury is allowed to hear would not normally be admitted as evidence in the guilt phase of the trial. In a death penalty case, the rules of evidence in what should be the most carefully scrutinized area of law are lax. As Sharon Turlington explains, this does not make sense. It does not. The rationale for this has been that while capital punishment demands increased reliability, the admission of more rather than less evidence during the penalty phase enhances reliability. If juries are not allowed to hear certain types of evidence because it is too prejudicial or not probative of an individual's guilt, why does that same evidence somehow transform into being more reliable simply because it is being introduced in the penalty phase? It seems that the opposite is true, that the sentence of death would be based more on past conduct than on the strengths of the facts on the current case. In the current case. This should not be acceptable if our constitutional standards truly require that the death penalty be applied in a rational and non-arbitrary way. The solution for allowing for the maximum amount of evidence to be presented to the jury while not violating Mr. Kohberger's constitutional rights is to have a trifurcated proceeding. While the Constitution prohibits the introduction of character evidence during the adjudication of guilt or innocence, it also requires the capital trial to include as much individualized information as possible about the defendant. And then it goes down after citing Hauser and says trifurcation respects both of these constitutional requirements. It allows the maximum amount of evidence about the defendant to be presented while still complying with the state and federal constitutions. The third phase, the sentencing phase, in which the jury determines whether death is the appropriate punishment, should be conducted like a regular sentencing proceeding in which the rules of evidence are not applied and other rights, including the right to confrontation, are limited. All the evidence and aggravation that the state seeks to introduce is admitted in the final phase for the purpose of determining an appropriate sentence. Several jurisdictions have used the trifurcated system, and it says to see United States versus Bowers from 2023, State versus Prince from 2011, United States versus Fell from 2008, and then it mentions Milliman, Limiting Death, Maryland's new death penalty law from 2010. A trifurcated system would also protect Mr. Kohberger's right to confrontation. Unlike Idaho, a majority of courts who have addressed the issue have recognized that the confrontation clause applies to evidence used to establish an aggravating factor necessary to make the defendant eligible for the death penalty, and then cites State versus McGill. 6 state high courts have agreed. See State versus Robinson, and then that's in Arizona from 1990. And then Rogers versus State from Florida in 2006, Pitchford versus State from Mississippi in 2010, State versus Bell from North Carolina in 2004, Russo versus State from here in Texas in 2005, and Grandison versus State from Maryland in 1995. The Fourth Circuit Court of Appeals has suggested that the right to confrontation applies during the guilt and eligibility phases of a trial per United States versus Umana. And this one is from, the Fourth Circuit in 2014, and it says the court explained. During the sentence selection phase of a capital trial, the jury exercises discretion in selecting a life sentence or the death penalty, and any facts of the jury might find during that phase do not alter the range of sentences it can impose on the defendant. Under the Federal Death Penalty Act, the jury finds the facts necessary to support the imposition of the death penalty in the guilt and eligibility phases of trial. It is only during these phases that the jury makes constitutionally significant factual findings. Other federal district courts have agreed. And then it cites United States versus Mills, California 2006, says that holding that Crawford versus Washington's protections apply to any proof of any aggravating factor during the penalty phase of a capital proceeding under the Federal Death Penalty Act. Some federal district courts have trifurcated the proceedings in order to comply with constitutional restrictions, and then cites United States versus Bodkins, and it looks like that one is from Virginia and from 2005. The court chose to separate the penalty phase into an eligibility portion and a sentencing portion because the court determined that if the defendants were convicted of one or more death-eligible offenses, the subsequent sentencing proceeding would be bifurcated into an eligibility phase followed by a selection phase. The district court explained that any testimonial hearsay evidence offered during the eligibility phase would have to meet the requirements of Crawford before it could be presented to the jury. Now, I don't know exactly what this Crawford versus Washington is, but hearsay is something that I didn't know was admissible in court at all, ever, until I was looking up the differences between state and federal grand juries and found out that hearsay is admissible evidence for federal grand juries. So someone can walk in there and literally make up a story out the ass and have no proof whatsoever, and it be considered actual admissible evidence. Ain't that some shit? So again, I don't know what this Crawford versus Washington is, but it sounds like hearsay can be admitted in these things, but it must meet certain requirements, which is good to know. The federal district court in the Northern District of Iowa chose trifurcation as well. United States versus Johnson from Iowa in 2005, the court concluded that trifurcation is required for 3 reasons. Of course they did. First, the court concluded that the danger of unfair prejudice arising from jurors hearing victim impact evidence or evidence on other non-statutory aggravating factors before the juries make their determination on the defendant's eligibility for the death death penalty on the basis of the gateway and statutory aggravating factors substantially outweighs any probative value of such evidence to the determination of the defendant's eligibility for a death sentence. Second, the court concluded that the information concerning gateway and statutory aggravating factors in this case is entirely severable from information concerning any other factor where the government intends to rely only on evidence admitted on the merits phase to prove the gateway and statutory aggravating factors, and introduction of extraneous information into the jury's determination of the gateway and statutory aggravating factors could only tend to confuse the issues. Third, the court concluded that if the jury is permitted to hear information on all of the factors in one proceeding, the jury is reasonably likely to be misled into believing that all the information is pertinent to the determination of all factors and the balance of factors. I understand exactly what this is saying, because it's true. The more you bombard people with information, the less they can actually think, the less they can think. The more that you're throwing at them, okay, because this isn't like class where you have books and you can go over things. I mean, obviously they get to see all the evidence and all that stuff, but whenever you're sitting there and you're trying to like determine what you're hearing and you're trying to decide, if they're throwing a bunch of stuff, like, guys, that whole hearing about the change of venue survey was one of the most boring 7-hour sessions of my entire life. Like, love chatting with you guys, but hell, that was so hella boring. And even if we hadn't gone through hundreds and hundreds of pages about the exact same thing a few weeks prior, it still would have been hella boring. Okay? You can't take a jury and throw that kind of cray-cray in their faces on top of all this other drama and just expect them to not implode. So separating things out is the best way to do it, because you do it in sections and it stops it from being done incorrectly. It stops from the wrong decision being made, and it slows down the process to where there can be less mistakes. I agree with this. The Federal District Court in United States versus Jordan from Virginia in 2005 also chose to separate the sentencing phases into two parts to avoid a confrontation clause problem. In holding that the confrontation clause applied to the penalty stage, the court distinguished between the two facets of the deliberative process in the penalty stage: eligibility and selection. The court held, from a constitutional perspective, the eligibility phase is the most critical because it is a necessary prerequisite to the jury's consideration of the death penalty. It encompasses the finding of fact that increases the defendant's authorized punishment from life in prison to death. Jordan then held, consistent with the constitutional safeguards identified by the United States Supreme Court, this court is of the opinion that with respect to the eligibility phase of the penalty stage of a capital trial, the confrontation clause is equally applicable. The district court found that a close examination of the governing statute reveals that the statute does not necessarily mandate a single unitary proceeding. The court found that the testimonial statement could be used in the selection phase, stating, unlike the eligibility phase, the selection phase is intended to be less structured and less encumbered by strict adherence to the rules of evidence. The court in Jordan concluded that unless its probative value is substantially outweighed by the danger of unfair prejudice, the jury should have as much information before it as possible when it makes the sentencing decision. I don't agree with that. Because if the dude's innocent, then the jury doesn't need to hear anything about how it impacted the victims. I'm sorry, but that's just the facts. If somebody has not even been determined as being guilty yet, there's no reason for the jury to hear how horribly heartbroken the families are, because that's going to make them not really pay attention to facts, and they're going to vote on emotion. That is not, do not pass go, do not collect 200. Let's not do that, okay? The court in Jordan thus chose to separate the proceedings because the government intends to offer evidence which, in this court's view, is inadmissible on the issue of eligibility, but permissible in the selection phase. Just as the federal district court found that the Federal Death Penalty Act does not mandate a single proceeding, neither does Idaho's death penalty scheme. Idaho Code Section 1925.15 refers to a sentencing proceeding, but does expressly prohibit splitting the proceedings into two parts. Section 192515 contemplates a variety of situations and even allows for the proceeding to be held before a different jury when necessary. In this case, given the extensive non-statutory aggravation that Mr. Kohberger anticipates the state will seek to introduce in this case, I am hella curious about what they know the state's going to present, because I know that this is probably a pretty typical response. Let's face it, lots of these things are used in death penalty cases. The same sort of things probably get cited over and over and over again. There's probably certain templates that get used, and then you input new information and stuff that's relevant and very much specific to the case, right? And I know, that everybody that is sitting there in court waiting to see if they're going to be found guilty or not knows that the prosecutors are going to present all kind of stuff to make them look bad. That's how it works. So while I know this is probably typical, it still makes me hella curious. Just saying. Failure to separate the penalty proceedings will lead to an arbitrary and capricious sentence in violation of the 8th Amendment to the United States Constitution and Article 1, Section 6 and 13 of Idaho Constitution. It will also violate Mr. Kohberger's constitutional rights under 5th, 6th, 14th Amendments to the United States Constitution, and they said that all in the very beginning. Let's get to the conclusion. Okay. Conclusion. Trifurcation of the proceedings is necessary to protect Mr. Kohberger's state and federal constitutional rights. Mr. Kohberger respectfully requests that this court grant the motion to trifurcate the proceedings into a guilt, eligibility, and sentencing phase, meaning let's see if he's guilty first. If he's found guilty, then we find out if it's bad enough for the death penalty. Then if we find out it's good enough for the death penalty, then we see if they actually want to give him the death penalty. There, I figured it out. Mr. Kohberger also asked this court apply the rules of evidence to the guilt and eligibility phases. And this was written by Logsden, and that's the 13th. That's the last page. But yes, I do agree with this. I definitely agree with this. This makes more sense. And honestly, why isn't the norm? Why isn't this the norm? You know, me and my daughter were just talking about this in the car, about how nothing is uniform in this entire United States. There's nothing united. There's nothing the same. There's no reason why this isn't how every single trial, no matter the crime, is handled. There should be separation. There's no reason. Like, this is really kind of messing with my brain. Like, are there people out there that were found guilty by a jury because impact statements from the victim's family were given before the guy or girl was even found to be guilty? And that moved decisions based off of emotion instead of actual evidence? Now I'm like hella curious. I just don't see how this isn't normal. Like, this sounds like this is how it should be. Why are we having to file motions for something that sounds like this is how it should be working? Oh man, okay, I'm just tired of trying to figure it out. This is why I don't do this for a living, because this is too stupid. It's just too dumb. Okay, now we have motion for court order. This is the next one, right? Yeah, number 3. Okay. 11 pages. Let's see. Motion for court order requiring the state, 1, to provide notice of every alleged non-statutory aggravating fact, circumstance it may rely on in any sentencing trial, and 2, to provide beyond a reasonable doubt every alleged non-statutory aggravating fact and circumstance. So anything like his past H use, any bad story that's come out since he was arrested, anything the state has that they're going to plan to use against Bryan when it comes to stuff that's not evidentiary, stuff that's not actually part of the actual physical evidence of this case, they want to know about it. And they want to know about it now ahead of time. Comes now Bryan C. Kohberger, by and through his attorneys of record, and hereby move this court for an order requiring everything I just said in the title. I'm not going to reread it. Number 1, notice of non-statutory aggravating facts and circumstances. In State v. Hall, Idaho from 2018, the Idaho Supreme Court held for the first time that evidence of non-statutory aggravating circumstances is admissible in the capital sentencing process, and that it may be considered by the jury in determining whether to sentence an individual to death or life imprisonment. Mr. Kohberger has argued elsewhere that Idaho's capital sentencing scheme, as articulated in Hall, is unconstitutional due to its arbitrary nature. That elsewhere would be that big old paper that we just went finish. Mr. Kohberger maintains those arguments here in the very next filing, of course. However, if the court disagrees and holds that non-statutory aggravating circumstance evidence will be admissible at any potential sentencing phase in Mr. Kohberger's case, then the court must enter an order requiring the prosecution to provide him with sufficient notice of any non-statutory aggravating fact or circumstance it intends to introduce and or rely upon during the sentencing phase, should one be held. Meaning if the court still allows this non-statutory aggravating evidence against Bryan into court, then they want to know what it is, which that's kind of how this works. Anyway, I thought, right? Like, why are we having to file things that sound normal? Like, shouldn't that be how that just works? Hey, if this is going to be admissible evidence, you've got to give it to them so they know about it. That's how this works. See, I'm dropping stuff. Oh, this is stupid. Like, I don't know why this is aggravating me. Like, I feel like this should be common sense. The fact that we have 14 filings for common sense to happen makes no sense to me. Such notice is required by the due process and the cruel and unusual punishment clauses of the United States and Idaho constitutions. In Lankford versus Idaho from 1991, the United States Supreme Court held that a trial court's decision to sentence the defendant to death violated the due process clause of the 14th Amendment because at the time of the sentencing hearing, Lankford and his counsel did not have adequate notice that the judge might sentence him to death. So they didn't warn him? I thought warning was normal. Lankford was charged with 2 counts of first-degree murder and had been advised at arraignment that the maximum punishment he could receive if convicted was either life in prison or death. However, after a jury found him guilty on both counts and prior to his sentencing hearing, the state indicated in a response to a pre-sentencing order that it was not recommending the death penalty as to either count. The sentencing hearing was held, and both parties made arguments about the relative merits of concurrent or consecutive and fixed or indeterminate sentence terms. Despite the fact that the death penalty was not discussed by either party, at the conclusion of the sentencing hearing, the trial judge sentenced Lankford to death based on 5 specific aggravating circumstances. Well, one doesn't normally just start with murder, and once you're caught with murder, if you're a criminal, like a career criminal, it's not your first one. So normally you do have other stuff in your background that could cause that. The Supreme Court reversed, holding that the trial's court silence following the state's response to the pre-sentencing order had the practical effect of concealing from the parties the principal issue to be decided at the hearing. I mean, I understand he should have been told that, but he was told it wasn't a possibility. Like, I don't feel bad for the guy. He apparently was a real murderer, but I could imagine, like, not expecting to be told that, and then poof, you're like told that, and I can imagine how that would like be. Yeah, okay. Notice of issue to be resolved by the adversary process is a fundamental characteristic of fair procedure. Without such notice, the court is denied the benefit of the adversary process. The court further noted, if defense counsel had been notified that the trial judge was contemplating, okay, but hold on. I actually don't even want to finish reading this part right here because that's not the case here. We've had notice of death penalty for a super long time, hence why they're now filing the motion against the death penalty. So I don't see, this is another one of those things, and again, I'm not a lawyer, so maybe I'm just not comprehending the reasoning, okay? But I don't understand why I'm constantly seeing people in this case when it comes to the defense and the state both bringing up things or citing cases or situations that don't have anything to do with anything here. Ann Taylor did it for the change of venue thing. She's kind of doing it here again, too. She's mentioning things. She's trying to have an argument. She wants to fill up 11 pages. But this has nothing to do with this situation. This is not the case here. Literally at all. I guess we're going to go on and read it. But I just feel like she needs to switch up the argument here. Because right now, this is irrelevant. The court at Lankford also cited to its prior decision in Gardner versus Florida from 1977, in which it relied upon the Due Process Clause of the 14th Amendment and the 8th Amendment's prohibition against cruel and unusual punishment to hold that a procedure for selecting people for the death penalty that permits consideration of secret information about the defendant is unacceptable. Failure to require the prosecution to provide the defense with sufficient notice of any evidence of non-statutory aggravating facts/circumstances it intends to introduce at the sentencing phase would be a blatant violation of Mr. Kohberger's 8th, 14th Amendment rights under Lankford and Garnier. Okay, but what I'm still not comprehending here though, like why she's using this. Because it doesn't state that they weren't going to talk about the stuff this guy had done in the past. All it said was that they weren't going to be recommending the death penalty for either of the charges. So, I guess I'm just not understanding the argument here. Because this just seems like the argument for Lankford is that he wasn't told that death penalty was on the table ever, and then all of a sudden he got sentenced to death. I hold my argument so far that this is irrelevant. This is irrelevant. Okay. Not only must Mr. Kohberger be able to adequately defend his life at sentencing, but this court must carefully screen such evidence in advance for admissibility. Yeah, for sure. The court can only do so if it requires the prosecution to provide the defense with advance notice of non-statutory aggravating fact circumstance evidence, which will enable the parties to engage in important pretrial litigation concerning the admissibility and reliability of any such evidence. Again, I feel like this should be just normal. I feel like this should just be how this normally works. Again, I guess I still just feel like common sense exists, even though I should probably know better by now. Even in jurisdictions where introduction of non-statutory aggravating circumstances is explicitly provided for by law, the discretion of the prosecution to introduce its evidence is not unbridled. And then it says, example is this USC, which is United States Constitution, 3593, permitting the government to present information about any aggravating factor for which it has given sufficient notice, provided that the government bears the burden of proving the factor beyond a reasonable doubt. Principles underpinning both the Eighth Amendment and the Due Process Clause mandate that judicial discretion be exercised and the non-statutory factors be carefully screened. And that is United States versus Davis from Louisiana in 1996. See also United States versus Bin Laden. Okay. Then it also states United States versus Solomon, and that one is from Pennsylvania from 2007. And that one says, if the non-statutory aggravator has only a tangential relationship to a determination of who is more worthy of receiving a sentence of death, it should be excluded from the sentencer's review. Among other considerations, judicial screenings evaluate the evidence and factor itself to determine admissibility under general principles that are now well established. The factor or circumstance cannot be unconstitutionally overbroad or vague. And number two, because that one was number one and I skipped reading number one, but now this is number two, it must be sufficiently relevant to the question of who should live and who should die. Number three, even if the factor or circumstance is relevant, evidence in support of it may be excluded if its probative value is outweighed by the danger of creating unfair prejudice, confusing the issues, or misleading the jury. And then it states United States versus Grande from Virginia in 2005, and then says to go back and look at Solomon again. It also says that in some jurisdictions, for number four, in some jurisdictions, including the Ninth Circuit, a non-statutory aggravating factor cannot duplicate another aggravating factor or an element of the offense. So it can't have anything to do with the offense itself, and it also can't be too similar to another factor. So they can't try to like double up on stuff. If it basically has the same basis, they can't use more than one example of one thing is basically what it means, I think. In jurisdictions that have statutes that permit introduction of non-statutory aggravating factors or circumstances, trial courts conduct a searching review of the evidence, an evidentiary hearing at which the court, in its role as gatekeeper, admits only that evidence which carries with it sufficient indicia of reliability, and then says to go back and look at Davis again. In an effort to assure those safeguards, this court will hold a pretrial hearing on the admissibility of the information the government intends to introduce in support of the non-statutory aggravating factors. And then United States versus Beckford from Virginia in 1997, the government must present to the court and to the specific defendants the information which it intends to introduce as unadjudicated conduct. The court will then determine whether the information is reliable. Only if the government satisfies that threshold determination will the evidence be presented to the jury. Idaho's capital sentencing statute gives this court the power and obligation to limit the prosecution's evidence. That's interesting. Now, what's going on right now in Delphi is interesting because almost everything that the defense has come up with from the discovery that was given to them by the state, including the very beginning initial investigators, Judge Gull has now said bye-bye. Like, you can't come in here and talk about Ron Logan. You can't come in here and talk about the actual investigator who was an actual employee that came up with the Odinism stuff and did interviews. You can't talk about Brad Holder. You can't talk about the Odinism. You can talk about none of the things. None of the other defenses or theories are allowed to be in court. So I know that they can put a halt on what's going on in court when it comes to the defense because they did it in Scott Peterson's case too. They purposely didn't talk about the Medina robbery. It was excluded. And they didn't talk about the witnesses that claim that they saw Lacey walking with Mackenzie after Scott apparently left that day. There was also a part about an eyewitness seeing Lacey Peterson at the warehouse where the boat also was at the exact same time that was removed from the report that Detective Al Brocchini wrote from another officer's report who actually talked to said warehouse witness. There's literally a transcript about them talking about it, and Al Brocchini admits to this, which is technically like a Brady violation. Technically. So I've seen it. I've seen it when it comes to the state not allowing the defense to have certain things presented. But I didn't know, I guess, that they could also put a halt to what the state can actually show as evidence. Because you'd think that that wouldn't be a thing. That evidence is evidence is evidence. It's up to you to determine what the actual facts are telling. Not to remove actual factual facts. I don't know if I like that. I don't know if I like that at all. At the special sentencing proceeding, the state and the defendant shall be entitled to present all relevant evidence in aggravation and mitigation. Disclosure of evidence to be relied on in the sentencing proceeding shall be made in accordance with Idaho Criminal Rule 16. Evidence admitted at trial shall be considered and need not be repeated at the sentencing hearing. This court has an obligation to screen carefully and limit the prosecution's so-called non-statutory aggravating fact and circumstance evidence in order to prevent arbitrary and capricious impositions of the death penalty. Now, that makes sense for this type of evidence. But this just states, this original sentence that got me going says, Idaho's capital sentencing statute gives this court the power and obligation to limit the prosecution's evidence. It doesn't start talking about that part of the evidence until it talks about what 6 actually claims, and it's talking about that kind of stuff. But it's not talking about, like, specifically non-statutory aggravating evidence, like the hearsay, the circumstantial, the past, all the stuff that we've been talking about this whole time. That's not specified in this right here. At the special sentencing proceeding, the state and the defendant shall be entitled to present all relevant evidence in aggravation and mitigation. All relevant evidence. Like, I know it's included in all relevant evidence, but it made me think for a minute there. They can really just, like, pull out real evidence for being presented, and that was not just okay with me. Okay, anyway. A U.S. District Court judge in Pennsylvania explained, the court's screening of aggravating factors is essential to channeling, directing, and limiting the sentencer's discretion in order to prevent arbitrary and capricious imposition of the death penalty and to satisfy the heightened reliability requirements of capital sentencing required under the 8th Amendment. And then talks about United States versus Hammer, and then United States versus Solomon again. And then states aggravating circumstances introduced in a capital sentencing proceeding must be relevant to the question of life or death. As one federal judge stated, Are there no limits on the other information that can be introduced at the penalty phase of a capital case? The answer is clearly no. The statute itself requires that any such information be relevant, and by relevant, it must mean sufficiently relevant to the consideration of who should live and who should die. And again, if you are being tried for one situation, but you've got a rap sheet with several other things that you have done that has shown an escalation in violence and not given a shit, that matters, especially when it comes to something like life or death. For sure. Then it says, thus a non-statutory aggravating circumstance must concern matters sufficiently severe to warrant consideration of the death penalty. While unadjudicated conduct may be admissible, it must be carefully monitored to avoid constitutional deficiencies. And then it mentions United States versus Grande and United States versus Friend. And then it states relevance and heightened reliability in the context of assessing a non-statutory aggravating factor in a death penalty scheme are two sides of the same coin. Together, they assure the twin constitutional prerequisites are affording a rational basis for deciding that in a particular case, death is the appropriate punishment and of providing measured guidance for making that determination. Those objectives can only be accomplished if the proposed aggravating factor raises an issue which A, is of sufficient seriousness in the scale of societal values to be weighed in selecting who is to live or die, and B, is imbued with a sufficient degree of logical and legal probity to permit the weighing process to produce a reliable outcome. That word was probably probity. Anyway, thus, relevance in the context of non-statutory aggravating circumstances is determined by reference to the statutory aggravating factors because those are the death-worthy factors as determined by the legislature. Such legislative guidance is particularly significant in this context because it should be presumed that Congress would not craft a statute which would defeat the fundamental objectives reflected in the Supreme Court's death penalty jurisprudence by relaxing the standards of reliability and relevance of non-statutory aggravating factors when it so carefully defined the statutory aggravating factors and in so doing, confined them to a strikingly high level of relevance and reliability. That is such a freaking long sentence, holy moly. Indeed, to relax the standards for non-statutory aggravating factors would defeat the goal of guided and measurable jury discretion and return us to an unconstitutional system where the death penalty is wantonly and freakishly imposed. You mean back in like the guillotine days? Because yeah, that was wild. Now it says to talk about Friend again, and then says, for all of the reasons set forth above, the prosecution must be required to give Mr. Kohberger notice of any and all non-statutory aggravating facts and circumstances that it intends to introduce and or rely on at a sentencing trial should one be held. That was number one, which again, I still am remaining the same train of thought when it comes to how they fought this in the beginning. The whole he was told no death penalty, then suddenly he was sentenced to death thing doesn't have anything to do with this situation. Now on to number two, which is burden of proof. In addition to requiring the prosecution to provide sufficient pretrial notice of non-statutory aggravating facts and circumstances, this court must require the state to prove beyond a reasonable doubt any non-statutory fact or circumstance it is permitted to introduce against Mr. Kohberger, meaning you can't just come in here blabbing your lips, you've got to have some proof of it. Failure to do so would violate the due process and the cruel and unusual punishment clause of the United States and Colorado constitutions. I mean, it should just violate it anyway, but why are we talking about Colorado? I mean, they do cite other cases from other places, but they should really only be arguing their own rules, in my opinion, anyway. I'm not a lawyer. Statutory aggravating factors are required to be proven beyond a reasonable doubt to the unanimous satisfaction of the jurors, or they cannot be considered at any stage by the jurors. The state must be held to a similar burden with respect to the other aggravating evidence that was created by and embraced by Hall. The statute does not mention the non-statutory aggravating circumstances or other aggravating evidence created in Hall, but in light of the power granted them by Hall and in light of precedent, the beyond a reasonable doubt standard should apply to them as well. Now it does have a little footnote. Did that just induce that? Bam! It moves the footnote to the front. That must be new. That must be new. Okay. The statute also has no logical place for such aggravating circumstances to enter the process. This is no surprise given that the legislature expressly removed the any aggravating circumstances language from the statute in 1995. Okay. In People versus Tennyson, the Colorado Supreme Court held that the burden is beyond a reasonable doubt. An instruction to the jury that they must be convinced beyond a reasonable doubt that any mitigating factors do not outweigh the proven statutory aggravating factors before a sentence of death can be imposed adequately and appropriately communicates the degree of reliability that must inhere in the balancing process. And it says to see Ford versus Strickland from the 11th Circuit from 1983. In the penalty phase of capital murder prosecution, the beyond a reasonable doubt standard prescribes the level of confidence that the jury would have in its decision. And then says State versus Wood, and it goes on, we are persuaded that the legislature, though not explicitly addressing the issue, would have intended no lighter a burden. And that's that footnote that we just read. The Tennyson court went on to explain in detail the importance of the beyond a reasonable doubt standard in matters of fact-finding in criminal cases, relying in part on this Winship case from 1969. The court then stated, these considerations assume profoundly greater importance in the process of determining whether a person convicted of murder shall be sentenced to death. They further inform and undergird our analysis of the degree of certainty our statute requires each juror to possess in order to support a conclusion that the balance between aggravating and mitigating circumstances tips in favor of death. The Tennyson court then held that the Colorado capital sentencing statute required the beyond a reasonable doubt standard at the fourth step of their statutory process. It cited the same reasons as those that supported its decision concerning the third step involving weighing, stating as follows, we are reinforced in our conclusion by the fact that under Colorado's statutory scheme, the jury would proceed to the fourth step in the unlikely event that the jury were convinced beyond a reasonable doubt that any mitigating factors and the proven statutory aggravating factors were exactly in balance. In those circumstances, it would be especially important that the jurors understand the fourth step is separate and independent and requires that our ultimate conclusion that death is the appropriate penalty be reached only if they possess the degree of certainty that is communicated by the standard of beyond a reasonable doubt. The non-statutory aggravating facts and circumstances are facts easily capable of being judged under the standard of beyond a reasonable doubt. Such facts, if introduced, may play a crucial role I guess they could have gone either way. Okay. The sentencing process, if the jury ultimately reaches this final step. Indeed, under Hall, the importance of these non-statutory facts and circumstances may supersede the importance of all other evidence offered by the parties at sentencing because they will be the final aggravating facts to which jurors will be exposed prior to rendering their final sentencing verdict. Unless the standard of beyond a reasonable doubt is applied to any non-statutory aggravating circumstances, the resulting process and any decisions in favor of a death sentence will lack the fairness and reliability required by the due process and cruel and unusual punishment clauses of the United States Constitution. And then cites Beck versus Alabama from 1980, talks about Gardner again, and then Mills versus Maryland from 1988. In reviewing death sentences, the court has demanded even greater certainty that in our criminal cases, and the jury's conclusion rested on proper grounds. California versus Ramos from 1983 is now cited. Qualitative difference of death from all other punishments requires a correspondingly greater degree of scrutiny of the capital sentencing determination. Then states Lockett versus Ohio from 1978, qualitative difference between death and other penalties calls for a greater degree of reliability when the death sentence is imposed. Failure to apply such a standard would also specifically violate the due process and cruel and unusual punishment clauses of the Colorado Constitution. See Tennyson. And again, I don't understand why they're allowed to say, hey, if this happens, it's going to violate another state's constitution, so we probably shouldn't do this. It seems kind of irrelevant to me. I'm just saying. I guess, again, I'm not a lawyer. I don't understand why they're talking about something in Colorado when this is an Idaho capital case. It don't make sense to me. This is the conclusion. Based upon the foregoing and argument to be presented at the hearing hereon, this court is respectfully requested to grant this motion that that wasn't written correctly. Something feels off about the way all that whole thing was just put together. Anyway, the state's notice of intent to seek death penalty be required to list any non-statutory aggravators the state wishes to present, and B, the state be required to prove any such aggravators beyond a reasonable doubt. Counsel requests this issue be set for a hearing estimated to last 30 minutes. So they want to talk about this separately in its own session, which, yeah, I understand why. Okay, now this looks like they're going to try to strike each aggravator separately. So these are all going to be very, very, very specific. So this first one is 6 pages, and it's the motion to strike felony murder aggravator. Okay. Comes now Bryan C. Kohberger by and through his attorneys of record, and hereby moves to strike the felony murder aggravator from the state's notice pursuant to Idaho Code 194004A. This motion is made on the grounds that a malice aforethought murder cannot be aggravated by a burglary that itself is predicted on the same murder. Okay. Issues. Whether felony murder can be predicted on a burglary itself predicated on murder. Whether malice aforethought murder can be aggravated by a burglary predicated on the same murder. Number 1, felony murder cannot be predicated on a burglary predicated on murder. I really hope they make this make sense. So far, they've done a good job of making me understand what they're trying to say towards the end of the document, but I'm not a lawyer. I've said that 18,000 times. Some of these terms, especially when it comes to all this stuff going on in this death penalty case, I am clueless. I am learning. A lot of this is firsts for me. So the next big one that we deep dive after the whole Idaho situation is over, hopefully some of this sticks. It'll make it a hell of a lot easier to understand. Okay. It is impossible to charge felony murder on the basis of a burglary with the intent to commit the murder in question. The state has given notice that it intends to show the murders in this case are aggravated because the murder was committed in the perpetration or attempted perpetration of a burglary, and the defendant killed, intended a killing, or acted with reckless indifference to human life. In count 1, the state charges that Mr. Kohberger committed burglary by entering a residence located at 1122 King Road, Moscow, with the intent to commit the felony crime of murder. Okay, so I'm just going to stop right here and say this for a second. If they try him first for the burglary and prove for the burglary right then and there with all of the stuff from Cy Ray that he wasn't at the location at the time of the crime, doesn't that make all of the other 4 murder charges completely null and void, and all of this stuff would be done and over with after the burglary was proven to be false? I feel like that's how this would end up going. Counts 2 through 5 all charge premeditated murder. In other words, the state seeks to prove the aggravated circumstance of this murder by showing intent to commit murder at the time of entry, meaning he only committed burglary, according to what they want to do. He only committed burglary and false entry, basically burglary, because he wanted to commit the murders. Burglary only happened because he wanted to commit the murders. That's their argument. As the Supreme Court of California has noted, in a case such as this, the felony murder rule is unnecessary. It cites People versus Farley from California in 2009. The purpose of the felony murder rule is to deter felons from killing negligently or accidentally by holding them strictly responsible for killings they commit. To deter felons from killing negligently or accidentally. Okay, see, that for one, a felon can accidentally kill someone and be innocent of doing something malice. Just like a regular person that's a non-felon can. Just like a non-felon can also kill someone negligently. But the fact that it's saying to deter felons from killing negligently, for one, you cannot... If an accident's going to happen, an accident's going to happen. This whole sentence right here is strange. Okay, I'm not even going to try to sit here and dwell on it. People versus Washington, California, 1965. There is no rational reason for a first-degree intentional murder to be enhanced by the fact that the murderer intended the killing at the time he or she entered the building. I mean, I understand what they're saying, but if you have to commit a crime in order to commit the crime you actually want to commit and you don't care, who cares? The freaking murder is way freaking worse than the burglary. So I don't really understand that argument about why it matters. Like, if you were willing to do something horrible, like take a life, suck it up, Buttercup. You're going to be charged for also breaking into the building that you broke into in order to do the bullshit. You know what I mean? I understand their argument with this because of what I just said previously. If the burglary thing gets tried first and just right then and there they prove he wasn't there at the time of the crimes, he was not at the location, all the evidence proves so, then the rest of it is irrelevant. But they want him to also be charged for burglary, the state does, if he's actually found guilty of the murders. I don't really see the problem with that, because if he really is truly guilty, he's never going to get out of those walls. So what does it matter if he's got another freaking charge? Nothing is going to change. It's not going to make his life any easier or any harder to have a burglary charge on his record after getting convicted of 4 murders. It seems like an irrelevant argument if someone's guilty, but if someone's innocent, I see the fight. Okay. States have taken different approaches to whether it is possible to charge felony murder where the felony is a burglary with the intent upon entry to commit murder. In Civac, whatever, versus State in 1986, our Supreme Court determined that the felony in a felony murder was a lesser included offense of felony murder. What? I'm not even going to pretend to know what that means. In doing so, it construed the phrase "in the perpetration of" or "attempted perpetration of" and Idaho Code 18-8004A from 86, which is the same as IC 192515 from 2023, to mean a murder in furtherance of the felony crime, which is exactly what I just explained a second ago about the This is State versus Hall, which they've mentioned several times so far, from 1963, and it says holding on this issue makes sense because without the robbery, the state would have received only a second-degree murder conviction against Civic. I don't think that even matters here, because if Bryan Kohberger gets convicted and found actually factually guilty of killing all 4 of these kids, there isn't going to be no second-degree nothing, because the dude's never going to see sunlight again. Plain and simple. I'm not even going to finish reading that little portion. Irrelevant. The concept of committing a murder in furtherance of a burglary committed with the intent to commit that same murder has been rejected by multiple jurisdictions. The C. Williams versus the state, and it's from Delaware from 2002, superseded by statute as stated in Comer versus state from Delaware 2009, and Parker versus state from Arkansas in 1987. As the court in Williams held, Williams burglarized the Charles home with the intent of murdering Mason. The murder was not committed to carry out the commission of the burglary. So he didn't kill somebody so he could finish stealing whatever was in the safe and get out without getting caught. He broke in order to actually take a life, which is what they're claiming here. So this part I find relevant. Had this purpose been to steal jewelry and Mason was killed to facilitate this thievery, a case for felony murder would exist. Here, however, the sole purpose of the burglary was to murder his victim. It just so happened she was in a place he was not permitted to enter. Thus, the murder, although in the course of the burglary, was not carried out in furtherance of it. And I understand that part too. I get it. I just don't care. If you're guilty, suck it up, Buttercup. But I also feel like it's completely useless to try somebody for something so useless when it's not going to make them be punished any further. There's nothing you can give somebody to make them live longer in order to punish them longer. It's just stupid to me. Anyway, thus, under Idaho law, a felony murder could not be based upon a burglary whose sole aim is murder. If that is so, the question is whether a deliberate intentional murder with malice aforethought can be aggravated by a burglary predicted on the murder itself. Meaning, if you knew you had to break into a place to commit the murder, I mean, yeah, you kind of know that, right? Like you can't, unless you're going to do something stupid to somebody that you live with. Normally, people don't invite in their killers. So, kind of like common sense here, at least not normally. Sometimes it happens. Sometimes it happens. Number 2, a malice aforethought murder cannot be aggravated by a burglary predicted on the same murder. New York's Court of Appeals has held it cannot. Okay, again, up here they're talking about, what was it, Cali? They've been talking about Colorado, and now they're talking about, what was it, New York. Again, I get it. I get it. But this is the same thing that me and my daughter was talking about. Like, why are there all these separate freaking rules for every little thing? Like, I understand that we have 50 states, but are we supposed to be a united nation? Like, one actual united country? Stuff like this when it comes to how somebody gets tried for murder, how somebody gets put on death row, all of those things should be uniform. We shouldn't have to have 14 filings for normal things. That's, again, I don't know why I feel the need to constantly say that in this, but I feel like a lot of common sense is lost when it comes to the justice system. A lot of common sense is lost. Okay. New York's Court of Appeals has held it cannot. In People versus Cahill from 2003, the court considered whether a man charged with killing his wife's murder could be aggravated because he entered his home to do it. Wait a minute. The court considered whether a man charged with killing his wife's murderer? The court began by considering the nature of the burglary and finding it is an aggravated trespass, a trespass with the intent to commit a different crime. Then the court noted that to reach capital murder, a murder must be intentional and have an aggravating factor. The court then found that a situation where the burglary is predicated on the murder intended is not adding anything to the murder. I am still hella confused. Whether a man charged with killing his wife, or is it killing his wife's murderer? Like, did he break into the house because him and his wife were separated? The way, see, who wrote this? Hold on a second. I'm just going to go straight all the way down right here. Logsden. Okay, I don't know if he's like talking and transcribing or if it's the same Tamsin Reeves chick. I'm going to assume that that's a woman. I don't know why I feel like it's a woman, but I feel like it's a woman. This person seems to misspell things, not misspell things, but misplace words. This is the exact same one. I think I mentioned this already like over an hour ago in this video. I know this one's a long one. This is the same person who didn't put sheath at the end of K-bar knife sheath in that document that we talked about in this video. This person makes these documents difficult because they don't proofread what they're doing and they're careless. Do better, Miss Reeves, because I've about had enough of it. Okay. The court then considered the common law basis of felony murder and how it diverges from its use in the capital arena. In the contrast to penal law 125-27-1, felony murder covers non-intentional killings, which is true, and honestly, I don't like that either. I don't really quite understand how somebody that does something accidentally gets harshly punished. Like, let me rephrase. I believe that parents that leave their children in hot cars deserve to go to prison. Okay. I believe that people that are careless whenever they drive and do things that take away their focus and they end up hurting or killing someone should go to prison. But there are instances where total freaking freak accidents happen. And just because of how it impacted the victims' families or the effect that it had on the ripple effect that death had, that accident turns into somebody else's life being destroyed for something that was not in their heart, soul, mind, thought, anything at all to ever do to someone. Now, I understand somebody being very negligent in their negligence of taking care of an object, let's say the brakes of a vehicle or something to that effect, then causing an accidental death and then them being punished because of their negligence. But there are still situations where things are complete accidents and things were just literally nothing you could do. It was out of everyone's control and it just happened. And those people still end up being punished because of the ripple effect from it. So I don't agree with this. I think there should definitely be things that are considered. And I know for a fact there's a lot of people that are serving time for things they shouldn't be. From things that I just said to people that have taken out people that are R-wording them, abusing them, and all these things, and they have taken a life in self-defense of either themselves or somebody else, and the justice system was not fair. There is a lot of things wrong with the justice system. Too many to even honestly start thinking about it. Just completely broken. Now, I'm actually not going to read all of this right here because I'm going to tell you now. Whoever committed this crime deserves the highest extent of punishment possible. So, I am still not convinced that Bryan Kohberger is the one who did this. So while I do understand why Ann Taylor is going through all of these arguments, I don't feel the need to read that big old chunk of stuff right there. I'm just going to start when it goes down here. The court ruled that burglary predicated on the very same murder it sought to aggravate cannot satisfy its statute. Finally, California, whose statute then used the terminology during the commission or attempted commission, made essentially the same holding in People versus Green. Now, it seems like the rest of this is just talking about felony murder, non-intentional killings, different sightings of different cases from New York and different places. I really don't want to go through all of this because regardless, this is a horrible case. And even though I don't believe Bryan Kohberger is guilty at this time, okay, whoever did this deserves the highest, okay? I'm not about to sit here and entertain this being anything lower than what it is simply because of my beliefs of who is the accused at the time. Because this is literally just talking about felony murder statute and all of those things. And this is what this is. Regardless of who is the guilty party, that's what this is. So we're just going to skip down. Down, baby, down here. Finally, California, whose statute then used the terminology during the commission or attempted commission, made essentially the same holding in People versus Green, and then talks about People versus McLean as well from 2003, and says, the legislature's goal is not achieved, however, when the defendant's intent is not to steal but to kill, and the robbery is merely incidental to the murder. I get it. If they can prove that he didn't commit the burglary because of location or whatever, then obviously, if he wasn't there at the time they're claiming he did the burglary, then obviously he didn't commit the murders, okay? But I am, again, if you are going to go and do something stupid and commit a crime in order to commit a crime, then you should be punished for all of the crimes that you committed in order to commit a crime. The court should hold that Idaho has the same understanding of its aggravation statute. For this court to rule it otherwise, it would have to overrule Civic, which it cannot do. But can't it? I mean, things get overruled all the time. So that's kind of a bold statement, honestly. Therefore, this court must excise the felony murder aggravator from the state's notice. Based upon the foregoing and argument to be presented at the hearing hereon, this court is respectfully requested to grant this motion that the felony murder aggravator in the state's notice pursuant to Idaho Code 18-4004A be struck, and the court not instruct the jury on the felony murder aggravator. Counsel requests a hearing on this issue. Counsel estimates requiring 20 minutes for the hearing. I just don't agree with the sentiment. I understand Ann Taylor's fight. I'm definitely not knocking her fight. I understand where she's coming from. I know what she's doing. But as somebody who believes in true justice, if someone's found guilty of one thing and they happen to have committed something else in the commission of doing that one thing they were found guilty of, cool, go ahead and put the other charges on them. I just have issues, like I said, with it being a waste of taxpayer dollars and time and all the things. It's a very catch-22 situation. That's why I always find myself in the gray area of a lot of things. I always end up finding like one way this way, and then I also feel a little bit about this way too. Like I'm just really in the middle about so many things. Again, I'm not knocking Ann's fight here. I'm not. It's a good argument. All of this, I mean, it's not Ann's. I guess it is Ann's, but Logsdon's, whoever's. I'm not knocking the defense team's fight. I just don't agree with it when it comes to true justice, because if Bryan really is guilty, then he deserves all of the things. So yeah, we're just going to continue on to the next one. I'm not knocking it. I know what she's doing. Okay. This next one, holy crap-oly, 21 pages long. These are so long. I'm already at like, I think almost 2 hours of recording time. And we have how many left? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. We've literally only done 4. Holy moly. Okay. Let's go. This one. Motion to strike future dangerousness aggravator. Like him being a danger to society if he gets out type thing? Based on past behaviors of this stuff right here? Is that what that means? I guess we're going to find out. Okay. Let's see. Okay, comes now Bryan C. Kohberger by and through his attorneys of record and hereby moves to strike the future dangerousness aggravator listed in the state's notice pursuant to Idaho Code 184004A. The state's aggravator should be struck because it fails to genuinely narrow a class of defendants eligible for death and provides no standards to the jury to avoid imposing the death penalty in an arbitrary and capricious manner. This first one, it says, fails to narrow the class of death-eligible defendants. Okay. And then 2 is impermissibly vague. And then 3 is irrelevant to culpability and therefore cannot be an aggravator. And that right there is their list of issues they're now arguing. Okay. Argument. The United States Supreme Court has stated that the Eighth Amendment's prohibition against cruel and unusual punishment made applicable to the states through the 14th Amendment prohibits a state from imposing the death penalty in an arbitrary and capricious manner. Instead, the sentencing body must be provided with standards which will genuinely narrow the class of crimes and the persons against whom the death penalty is imposed. And then it cites Zant versus Stevens from 1983 and also Gregg versus Georgia from 1976 and Furman versus Georgia from 1972. To pass constitutional muster, a capital sentencing scheme must genuinely narrow the class of persons eligible for the death penalty and must reasonably justify the imposition of a more severe sentence on the defendant compared to others found guilty of murder. Lowenfeld versus Phelps from 1988, also citing Zant. The court stated, the narrowing function required for a regime of capital punishment may be provided in either of these 2 ways. The legislature may itself narrow the definition of capital offenses as Texas and Louisiana have done, so that the jury finding of guilt responds to this concern, or the legislature may more broadly define capital offenses and provide for narrowing by jury findings of aggravating circumstances at the penalty phase. The clear provisions of the Idaho statute provide that the narrowing occur in the sentencing phase of the trial, particularly here, where the allegation is simply premeditated murder. See State versus Hall. They are mentioning a bunch about Hall. Finding aggravating circumstances in Idaho are in both the definition of the crime and in the statutory aggravating circumstances. That said, aggravating circumstances must meet 2 requirements. The circumstance may not apply to every defendant convicted of murder. It must apply only to a subclass of defendants convicted of murder, genuine narrowing. And the circumstance must not be unconstitutionally vague. And then it mentions Tulipe versus California from 1994. Claims of vagueness directed at aggravating circumstances defined in capital punishment statutes are analyzed under the Eighth Amendment and characteristically assert that the challenged provisions failed adequately to inform jurors that they must find to impose the death penalty, and as a result leaves them and appellate courts with the kind of open-ended discretion held invalid in Furman versus Georgia. And then it cites Maynard. A statutory aggravating factor is unconstitutionally vague if it fails to furnish principled guidance for the choice between death and a lesser penalty. And then it states Maynard versus Cartwright from 1988, Godfrey versus Georgia from 1980, and then goes on to state that in State versus Creech from 1983, the Idaho Supreme Court upheld the propensity aggravating circumstance as being constitutional. In doing so, the court construed the word propensity as follows. We would construe propensity to exclude, for example, a person who has no inclination to kill, but in an episode of rage, such as during an emotional family or lover's quarrel, commits the offense of murder. Okay, but they already said from the very beginning this was not a crime of passion. And that to me sounds like a crime of passion, which this isn't supposed to be. So again, this feels like another one of those irrelevant arguments. We'll see. We would doubt that most of those convicted of murder would again commit murder. What? Nah. No. And rather, we construe the propensity language to specify that person who is a willing, predisposed killer, a killer who tends towards destroying the life of another, one who kills with less than the normal amount of provocation. We would hold that propensity assumes a proclivity, a susceptibility, and even an affinity towards committing the act of murder. Are we Dr. Seuss? Seriously. The court noted that in Jurek versus Texas from 1976, the court rejected an argument that the circumstance of a probability that the defendant would commit criminal acts of violence that would constitute a continuing threat to society, see what I said, was unconstitutionally vague. But it's not. See, I don't agree with this either. Again, I understand what they're trying to do. They're doing their due diligence argument fight for their client. I get it. But unless it's an actual proven accident in which somebody should not be being proven guilty of anything in the frickin' first place, you cannot sit there and tell me that when somebody would be getting away with murder, they wouldn't then be just easily, it would be easier for them to make that decision the next time because they've already done it. Now, granted, some people that would happen to would literally probably never do it again. It would probably even maybe, do serious harm to them, cause them to have PTSD issues. Okay, it all depends. But for someone to just be somebody who's committed stuff in the past, and now you've escalated to this, to sit there and think that they wouldn't do something else worse the next time is ignorance. So I don't believe in this argument. I understand again what they're trying to do here, but I very much disagree. Both holdings are problematic. I'm not even going to finish reading that. I'm just not. Both holdings are problematic within the jurisprudence outlined above. First, the Idaho Supreme Court's definition of propensity to commit murder matches and even makes use of the language from the definition of murder. Essentially, the court excluded manslaughter. Second, the United States Supreme Court failed to recognize that the vagueness inherent to the question of whether a particular individual poses a threat to society is that the very factors that might lead one person to conclude they should die may be thought of by another as a reason for mercy. See, and that's all about perception. That's all about perception. If you've lived a life where you haven't really had a lot of tragedy, you haven't had a lot of sadness, you haven't had things happen to you that are bad, you would most likely feel more empathetic towards situations for people that are actually doing wrong things than somebody who has been wronged and had wrong things done to them quite often throughout their journey here on earth. So it is all about your environment, your perception, the way that you are, what you've become based off what you've gone through. I completely agree with that sentiment. It is not clear from the decades of authorities on the subject whether the homicidally inclined, is that a diagnosis? Can you be diagnosed as homicidally inclined? That's wild. Are to be despised or pitied. Finally, such evidence is not relevant to determining which defendants are culpable of acts worthy of the death penalty. Okay, and then it goes on to start talking about the first one, which is fails to narrow the class of death-eligible defendants. The gloss placed on future dangerousness by the Idaho Supreme Court makes anyone who is found guilty of murder a candidate for death. This is because the court's holding differentiates murder from manslaughter rather than creating a subclass of murders. Murder is defined in Idaho as the unlawful killing of a human being, including but not limited to a human embryo or fetus with malice aforethought, or the intentional application of torture to a human being, which results in the death of a human being. Torture is the intentional infliction of extreme and prolonged pain with the intent to cause suffering. It shall also be torture to inflict on a human being extreme and prolonged acts of brutality, irrespective of proof of intent to cause suffering. The death of a human being caused by such torture is murder, irrespective of proof of specific intent to kill. Torture causing death shall be deemed the equivalent of intent to kill. And then it goes on, the Supreme Court's interpretation of future dangerousness would clearly catch all torturers within its ambit. So the only question is whether those who unlawfully kill with malice aforethought are meaningfully separate out by court's gloss. Are meaningfully separated out by the court's gloss? See, this freaking court clerk should not have this job. I'm sorry, but not sorry at the same time. When I am reading and I know that my brain is working very quick, and I know that the way that y'all hear me talking very fast whenever I read is nothing compared to what it sounds like in my head, okay? Okay. And I have to stop because she doesn't double check what she's doing. It's annoying. Let me do this. I would get marks off. I would get all kind of bad X's on my Q&As from all of my work audits, okay, if I did this kind of stuff. Do better or hire better. I don't know what else to tell you. The legislature defines malice aforethought as such malice may be expressed or implied. Expressed or implied? It is express. You mean expressed? It is expressed when there is manifested a deliberate intention unlawfully to take away the life of a fellow creature. It is implied when no considerable provocation appears, or when the circumstances attending the killing show an abandoned and malignant heart. Meaning you got a black heart like they have on Once Upon a Time, where it's all black. It takes out their chest and is just beaten black. That's what that means. This language corresponds almost exactly with that used, again, missing the D. Y'all know what I mean. I don't understand why this person has so many mistakes in this. This is really getting me like aggravated. Like it's already 10:15. I've been recording for a while. So I'm already getting aggravated enough because this is taking a lot longer than I wanted it to. But having these mistakes is just making me aggravated for real. I know y'all can see that, but I'm going to really try to just like calm it down. Okay. By the Supreme Court to define those with a propensity to kill. We would construe propensity to exclude, for example, a person who has no inclination to kill, but an episode of rage, such as during an emotional family or lover's quarrel, commits the offense of murder. Now, again, they've been saying from day one, not a crime of passion. So unless it is rage, because if any of the other theories are accurate, then I guess it would be a rage situation, whether it be a drug related scenario or the fraternity scenario or anything like that. You still have to have a lot of something going on there in order to accomplish what was accomplished. So maybe they just mentioned that wasn't a crime of passion because they didn't want people to think that Ethan went in there and did a bunch of crazy stuff, because we do have a lot of hurting somebody else before then hurting your own self scenarios. Thank you for me having to speak YouTube. But yeah, maybe that's why they came out and said it that way, and so that people would maybe stop pointing fingers at Jack D when it came to Kaylee. I don't know. There could be some reason why they mentioned that, because what's the difference, honestly, between episodes of rage and crimes of passion? To me, they're sort of the exact same thing. Crimes of passion maybe is just the verbiage that they use whenever it's a relationship, but if you're doing something that's a crime of passion, isn't it just a very deep inside of your soul rage? Same thing. We would doubt that most of those convicted of murder would again commit murder. See, they said this again. This is the exact same argument, it sounds like. Okay. These definitions are essentially the same. 1, both definitions rely on a lack of provocation. 2, a propensity, an inclination, a willingness, an affinity, and a tendency towards murder are all synonymous within this context. Inclination/propensity, as defined by the Oxford American Dictionary, means a person's natural tendency or urge to act or feel in a particular way. Like when somebody is just careless and doesn't think before they act, and you know that they're going to always make the wrong decision because that's their track record. That's somebody's natural tendency to just be a complete F up. Okay. A spontaneous or natural liking or sympathy for someone or something. Affinity means a spontaneous or natural liking or sympathy for someone or something. To be willing is to be inclined to do something. To have a predisposition towards a thing is to have a liability or a tendency to hold a particular attitude or act in a particular way, as I just mentioned. If someone is constantly making the wrong choice, knowing the consequences, then that person just has a tendency of being somebody who is a self-sabotager and a narcissist. Those are just examples. The Oxford American Dictionary defines susceptibility as the state or fact of being likely or liable to be influenced, should say influenced, but again, it's missing the D, or harmed by a particular thing, meaning vulnerability. Like an elderly person or a child has the susceptibility of being abused by somebody because they can't defend themselves. That's how I'm understanding that. That's how I'm describing that. It would be impossible for a person to be inclined to murder without being susceptible to the concept. Okay, so here in Texas, we had a story of an 8-year-old who shot a man that he didn't know. I did do a video about it and then I deleted it because I didn't really know how to handle it. I just really didn't know how to handle it. It was only up there for like a couple of months and then I decided to delete it. But I think I'm going to talk about it again and I'm going to get the family's information and everything from the victim's family. Because this kid was 8 whenever he did this and kept it to himself for 2 years until he was 10 years old and he threatened another to take another life. He threatened a child at school, like I think on the bus. Now my friend Chris on Twitter was in a conversation that popped up on my news feed just because we follow each other. So I guess it just shows me when he's having conversations with other people. Like I noticed it does that. I don't really know how Twitter works. But the story was about a 10-year-old that killed a man and his girlfriend in their home. 10. Now, a lot of people try to say that people that young don't understand the concept of death. They don't understand that it's forever, but I don't think that's true. I don't think that's true. An 8 and a 10-year-old, apparently, obviously, can commit it without being completely aware of what it actually means. I mean, didn't we have like a 12-year-old girl who took a blade and attacked her little brother on the couch just randomly for no reason and took his life about a year ago? For no reason. She's literally sitting on the front yard crying with the cops cuffing her and she's like, I don't know why I just did that. She was able to commit it without completely being able to comprehend why she's doing it or what it's going to end up meaning in the end before it was too late. So I don't really agree with it would be impossible for a person to be inclined to commit murder or to be inclined to murder without being susceptible to the concept. I don't agree with that. That's just how my brain is taking it. I don't agree with that. 3, to kill without inclination, propensity, or intent, but in a fit of rage, is traditionally understood to be manslaughter. That's true too. If 2 persons suddenly fall out and fight, and in the contest one kills the other, that is manslaughter. The blood is heated, the passions boil, rage indicates his conduct, and whilst the blows start passing, there is no leisure for reflection, nor time for reason to assume its empire, meaning he's not doing it because he wants to. It's basically like self-defense. It's you or him, basically. Indeed, Idaho defines voluntary manslaughter as the unlawful killing of a human being, including but not limited to a human embryo or fetus without malice. It is of 3 kinds. 1, voluntary upon a sudden quarrel or heat of passion. Therefore, the Supreme Court's gloss is a list of synonyms that define anyone who would commit murder as already defined by the legislature. It does not accomplish the genuine narrowing acquired by the 8th Amendment. Number 2 is impermissibly vague. The United States Supreme Court held that future dangerousness was not vague as it was something judges had to do all the time. Jarrett versus Texas from 1976. I've mentioned this one before. While this is true, the vagueness of future dangerousness does not lie in what the concept means, but what a jury is intended to do with the information. Traditionally, future dangerousness was seen as mental illness. Yeah, normally, if you can go out and completely constantly do crazy ass crap and hurt people in any way and just constantly do it, yeah, you got a problem up there, which in turn was seen as a mitigating circumstance. The Supreme Court has, confusingly, also held to this traditional understanding in reversing death penalty cases. It is evidence of future dangerousness, both an aggravating and mitigating factor. If it is, then how can this evidence be adequate to inform jurors what they must find to impose the death penalty, and as a result, leaves them in appellate courts with the kind of open-ended discretion held invalid in Furman versus Georgia? As the founding and throughout the 19th century, mental illness was a different issue for the judiciary. Why are we talking about this? Why are they going to try to play this game if he gets proven guilty or something? Curious. Unless it's just standard, I don't know. Theories about how the mind operated led many scholars to conclude that negative behaviors were symptoms of mental illness and thus removed responsibility for all evil actions, which I don't believe in either. You can have certain mental disorders like bipolar depression, even manic bipolar depression, like all kinds of different things. You honestly can't have a million different diagnoses, okay? And still know the difference between right and wrong. There are very few mental health diagnoses that makes you completely unaware of what you were taught as a human on how to human. Just saying. In essence, since no rational being would behave badly, all criminals were madmen. No, that's an ignorant thought. I'm glad that's not how it is anymore, because that's absolutely stupid. While psychology has come a long way since the 19th century, the definition of mental disorder still contains the basic concept that a person choosing sustained negative behaviors is mentally ill. According to the DSM-V, a mental disorder is a syndrome characterized by clinically significant disturbance in an individual's cognition, emotion regulation, or behavior that reflects a dysfunction in the psychological, biological, or developmental processes underlying mental functioning. Mental disorders are usually associated with significant distress or disability in social, occupational, or other important activities. An expectable or culturally approved response to a common stressor or loss, such as the death of a loved one, is not a mental disorder. Socially deviant behavior, example, political, religious, or sexual, and conflicts that are primarily between the individual and society are not mental disorders unless the deviance or conflict results from a dysfunction in the individual as described above. You can go out and be a thief and a loser and do all kinds of crazy stuff and still not be chemically imbalanced. Let me make that clear now, because, okay. Practically speaking, every case where a jury is asked to find a person is likely to pose a threat of future dangerousness will involve underlying significant disturbances in that person's mental functioning. From the Supreme Court's view, a mental illness is a type that renders a person unable to understand the meaning of or reason for its bars the application of the death penalty. All other forms of mental illness are mitigating, and only an ineffective attorney would not fully investigate and consider presenting such evidence to a jury. Yeah, that's honestly something that gets put out there a lot, like the mental illness defense or whatever. It's out there more than it needs to be. Way more than it needs to be. In turn, legislatures have labeled this same evidence as aggravating by pointing out that the factors that reduce culpability are increasing the threat that defendant in question poses to society. There is nothing new about making this observation, but by placing the legislative weight on the aggravation side of the scale, the evidence considered constitutionally mitigating is rendered a danger to the capital defendant. And then it cites Penry versus Leno from 1989, abrogated on other grounds by Adkins versus Virginia from 2002, and also cites Royal versus Taylor from the Fourth Circuit in 1999, noting that evidence of psychological impairments as a mitigating factor in sentencing can be a double-edged sword. Now, we do need to remember that there were some Reddit posts about visual snow that were found that were apparently Bryan's. So I don't know if that's why she's presenting this in here like this or what. But I find that arguments about mental health and all those other things should probably come after we get a sentencing. Because number one is to find out if the person was actually at the location at the time of the crime and actually committed the crime. And then part two should be the reasonings, I guess, for the actual crime, because facts are facts and motivation, motive, whatever, doesn't even actually matter. We all want to know the reason why, but the facts are supposed to speak for themselves, and the emotions behind such actions are null and void. It's just the story that people actually like to hear, but it's not necessary. Those portions should technically come in the second portion of these processes after the person is found to be guilty. If then it is found that they are guilty because of a mental illness, that's something completely different. But I don't really quite understand why some of these arguments are even taking place right now. But again, I'm not a lawyer, and maybe that's why I don't understand it. I'm sure there's other people out there like Emily and Lawyer and Defense Diaries and Andrea Burkhart and all of them that know better than I do about why they're arguing things that seem so irrelevant to the layman. Because this stuff seems so irrelevant to me right now. The best response to this decision the Supreme Court has made is that though the legislature renders the evidence aggravating at the base of a death-qualifying pyramid, the jury can still treat it as mitigating at the apex. And then it mentions Walter versus Arizona from 1990 and Zant versus Stevens from 1983. That explanation of how the system is to work is made all the more, what the heck is that? Kafkaesque? I'm so confuzzled. What is this word? It's an adjective used to describe situations that are disorientingly complex, bizarre, or illogical. So this case itself, how do you say it? Pronunciation. Kafkaesque. Sure, what she said. Okay. By states like Idaho that require defendants to give up rights and privileges in order to introduce evidence of a mental disorder. The system is not well served by permitting the legislature to make the purpose of psychological evidence unclear for juries. Studies have shown that juries are confused by the double intentions behind such evidence and typically find it aggravating. And then it says to see the overview of the task force proposal on mental disability and the death penalty from 2005, and I guess to see Exhibit A. Okay. Therefore, for the clarity of the jury, the future dangerousness aggravator should be struck in this matter. See, and I don't believe that. Again, for sentencing, if Bryan is found guilty, then for sentencing, yeah. But all the other parts of it, no. The facts of the situation first, which is how this should be going, which is probably still how this is going. But all of this being like talked about right now is sort of honestly kind of throwing me off. These death penalty cases are insane, but I'm glad that I'm digging into one so deep because I want to learn. I want to learn about all of this stuff. Okay. Number 3 is irrelevant to culpability and thus cannot be an aggravator. More concerning from the constitutional standpoint is that the United States Supreme Court has never actually held that evidence of future dangerousness is relevant to whether someone should die. Well, they should have, because it does. The Eighth Amendment requires that defendants only be condemned to death if they are deserving of the ultimate punishment based on their culpability, not their dangerousness. And then it states Adkins and California versus Ramos from 1983. The United States Supreme Court held, Closely related to, yet distinct from the respondent's speculativeness argument, is the contention that the Briggs instruction is constitutionally infirm because it deflects the jury's focus from its central task. Respondent argues that the commutation instruction diverts the jury from undertaking the kind of individualized sentencing determination that, under Woodson versus North Carolina, is a constitutionally indispensable part of the process in inflicting the penalty of death. As we have already noted, supra at 3454 is a functional matter that Briggs instruction focuses the jury's attention on whether this particular defendant is one whose possible return to society is desirable. In this sense, then, the jury's deliberation is individualized. The instruction invites the jury to predict not so much what some future governor might do, but more what the defendant himself might do if released to society. Any contention that injecting this factor into the jury's deliberations constitutes a departure from the kind of individualized focus required in capital sentencing decisions was implicitly rejected by the decision in Jurek versus Texas. Indeed, after noting that consideration of the defendant's future dangerousness was an inquiry common throughout the criminal justice system, the joint opinion of Justices Stewart, Powell, and Stevens — why is Powell and Stevens like hella capitalized, but Stewart's isn't? Probably just a mistake — observed, what is essential is that the jury have before it all possible relevant information about the individual defendant whose fate it must determine. Texas law clearly assures that all such evidence will be adduced. As with the Texas scheme, the California sentencing system ensures that the jury will have before it information regarding the individual characteristics of the defendant and his offense, including the nature and circumstances of the crime and the defendant's character, background, history, mental condition, and physical condition. More to the point, however, is the fundamental difference between the nature of the guilt/innocence determination at issue in Beck and the nature of the life/death choice at the penalty phase. As noted above, the court in Beck identified the chief vice of Alabama's failure to provide a lesser included offense option as deflecting the jury's attention from the central issue of whether the state has satisfied its burden of proving beyond a reasonable doubt that the defendant is guilty of a capital crime. In returning a conviction, the jury must satisfy itself that the necessary elements of the particular crime have been proved beyond a reasonable doubt. In fixing a penalty, however, there is no similar central issue from which the jury's attention may be diverted. Once the jury finds that the defendant falls within the legislatively defined category of persons eligible for the death penalty, as did the respondent's jury in determining the truth of the alleged special circumstance, the jury then is free to consider a myriad of factors to determine whether death is an appropriate punishment. In this sense, the jury's choice between life and death must be individualized, but the Constitution does not require the jury to ignore other possible factors in the process of selecting those defendants who will actually be sentenced to death. Zant versus Stevens from — it doesn't say. Okay. As we have noted, the essential effect of the Briggs instruction is to inject into the sentencing calculus a consideration akin to the aggravating factor of future dangerousness in the Texas scheme. This element is simply one of the countless considerations weighed by the jury in seeking to judge the punishment appropriate to the individual defendant. That is not in Texas. So again, I don't know why we arguing this stuff. I guess I'm just not going to comprehend why stuff outside of Idaho even matters right now. In Skipper versus South Carolina from 1986, the court ruled that evidence showing that a person will be a well-behaved prisoner, despite having no relevance or culpability, was relevant mitigating evidence. Thus, the court has only tangentially considered the issue. This court should consider the question directly. If the Eighth Amendment requires that the death penalty only be imposed on the worst of the worst, whose culpability supports such a punishment, how is risk of future dangerousness relevant? Oh, yeah, that makes sense, actually. If the death penalty is only supposed to be imposed on the worst of the worst, then what's the point? Because they're not going to get out. So why are we even talking about it? Is that what she means? I guess that makes sense, because if they're not going to get the death penalty, then future dangerousness should be considered. But if they're going to get the death penalty, it's completely pointless. That's this whole argument. So I really don't feel the need to read much more of these 21 pages. Oh, well, it's right here anyway. Thus, this court shall strike future dangerousness aggravator. Okay, what conclusion? Based upon the foregoing argument to be presented at the hearing hereon, this court is respectively requested to grant this motion that the future dangerousness aggravator in the state notice pursuant to Idaho Code 18-4004A be struck, and court not instruct the jury on future dangerousness. Okay, but I really hope that means just for, like, in case there's a death penalty. Because if there's not a death penalty and he is found guilty, which if he is found guilty, there's going to be a death penalty. Ain't no way he ain't going to get it. So for this case, I understand it. But for another case, I mean, I understand the argument completely. There's no point for even saying anything else about another case. Okay. This is the synopsis of the death penalty and mental illness thing that they were talking about, that they were citing a whole bunch. We're not going to read this. We just not gonna do it. Okay, so now we're gonna go down to motion to strike HAC aggravator. I don't know what that means. Again, with 21 pages, is some of it something different? Just curious. Wow, it's so much, so much. Okay, I have no idea what HAC aggravator means. So I Googled it, or I guess I should say I Binged it. And it basically just says that that's what they used when the capital felony was especially heinous, atrocious, or cruel. Up here, it also talks about it being extremely wicked or shockingly evil or vile. And see, I have issues, guys. I have issues because that's exactly what this crime was. That's exactly what this crime was. I guess I just don't understand why they even argue anything about death penalty unless someone's actually found guilty. It seems like a huge waste of time. Unless there's actually a guilty sentence, like a guilty verdict. I've probably said that I felt like a lot of these things were a waste of time quite a few times. Okay, let's just go ahead and start this one now. Comes now Bryan C. Kohberger, by and through his attorneys of record, hereby moves this honorable court for an order striking from the state's notice pursuant to Idaho Code 18-4004A the allegation that the murder was especially heinous, atrocious, or cruel, manifesting exceptional depravity. But just from the very minute details we've heard, that's what it was. Just because I am not convinced that Bryan Kohberger is guilty does not mean that that takes away any severity from the crime. That's why I'm having issues with this, guys. I'm having a lot of issues with this. A lot. This motion is made on the grounds that the aggravator is unconstitutionally vague and fails to narrow the class of eligible candidates for death, partly because the Idaho Supreme Court cannot constitutionally place a limiting construction on the statute, and partly because it has not in practice done so by omitting its construction from the Idaho constitutional, whatever JI actually means. What do you mean? See, this... Okay. How is somebody saying that a crime is especially heinous, atrocious, and cruel and has exceptional depravity? How is that being vague? How is that failing to narrow anything? That is very specific. Because somebody can pew somebody and it still be a death penalty case. But somebody could take a manual weapon and do a whole bunch of great crap, okay, like the Ripper case for one, all right, and it be considered this. You can narrow it. Let's quit playing around. Eighth Amendment. The United States Supreme Court has stated that the Eighth Amendment's prohibition against cruel and unusual punishment, made applicable to the states through the 14th Amendment, prohibits a state from imposing the death penalty in an arbitrary and capricious manner. See, that's why I feel like a lot of this stuff is just formatting. We've repeated the same sentences, I don't even know how many times. Instead, the sentencing body must be provided with standards which will genuinely narrow the class of crimes and the persons against whom the death penalty is imposed. And it cites Zant versus Stevens from 1983 again. And guys, I know I'm touching my hair a lot, okay, but something feels off back here and it keeps getting in my face. And at this point, I've been sitting here for 3 hours. And I started recording right before like 7:30. It was like a few minutes before 7:30. It was like 7:27. So my hair is getting on my nerves, just so you guys know why I keep fidgeting with it so much all of a sudden. Okay. Now it also says to see Gregg versus Georgia, and that one's from 1976, and again mentions Furman versus Georgia, and then something about Brennan. I don't know. There's a whole bunch of U.S. codes right here. To pass constitutional muster, a capital sentencing scheme must genuinely narrow the class of persons eligible for the death penalty and must reasonably justify the imposition of a more severe sentence on the defendant compared to others found guilty of murder. And it cites Lowenfield versus Phelps from 1988, and they cite Zant talking about how the narrowing function required for a regime of capital punishment may be provided in either of these two ways. They have already said this. The legislature may itself narrow the definition of capital offenses, as Texas and Louisiana have done. We've read this already. I am not going to read all of this exact same stuff again. And look here at it again. Tulapia versus California. Claims of vagueness directed at aggravating circumstances defined in capital punishment statutes are analyzed under the Eighth Amendment and characteristically asserted that the challenged provisions fails adequately to inform jurors what they must find to impose the death penalty, and as a result leaves them and appellate courts with the kind of open-ended direction held invalid in Furman versus Georgia. It is the exact same argument. I already read all of that. And look, right here, judicial gloss. We've talked about this stuff already. All right, legislative history. Idaho's legislature has made it an aggravating circumstance where the murder was especially heinous, atrocious, or cruel, manifesting exceptional depravity, and that is 1925-15-9E. This aggravator first appeared in the Model Penal Code in 1962. The state of Idaho shares this exact statutory language with one other state, California. The Supreme Court of California has ruled that this language is unconstitutionally vague. How? Very specific to me. Judicial gloss. Idaho's highest court has placed a judicial gloss on this statute such that the state must show. We feel the meaning of such terms is a matter of common knowledge, so that an ordinary man would not have to guess at what was intended. I'm sorry, but I'm an ordinary man, woman. And I understand that whenever I am being described something as especially heinous, I got a pretty good idea what they're talking about. So, again, this is like, just in case people are too stupid, we got to come up with all this crazy stuff to make it even more complicated. That's basically what it sounds like to me. It is our interpretation that heinous means extremely wicked or shockingly evil, that atrocious means outrageously wicked and vile, and that cruel means designed to inflict a high degree of pain with utter indifference to, or even in enjoyment of, the suffering of others. What is intended to be included are those capital crimes where the actual commission of the capital felony was accompanied by such additional acts as to set the crime apart from the norm of capital felonies, the conscienceless or pitiless crime which is unnecessarily torturous to the victim. In interpreting this portion of the statute, the key word is exceptional. It might be argued that every murder involves depravity. The use of the word exceptional, however, confines it only to those situations where depravity is apparent to such an extent as to obviously offend all standards of morality and intelligence. See, this is honestly making me wonder if a lot of the original rumors were true about some things, like about body parts missing and stuff like that. Because I understand for people, a blade, the way that it probably looked, I get it. I understand it. But I'm wondering if they'd be using these types of wordings for this if it was literally just a bunch of life ending wounds instead of things with other intentions. But the timeline they're giving us, and I've mentioned this I don't even know how many times, the police's own timeline of the events is what is causing their story not to make any sense. On top of the fact they don't have any evidence. But before we knew they actually had no evidence, their own timeline was working against them. They're giving us like a 7 to 9 minute window for this person to have driven into the neighborhood, gotten out of their vehicle after finally getting out of it. Because I'm telling you, and I've mentioned this again too, I've done videos, I've done a 3-part series, and I've gone back and looked at it over again, and I'm not changing my mind. From what the police told us in the PCA, all the noises Dylan is apparently claiming to have heard, or that they're telling us that Dylan is claiming to have heard, that vehicle that they're claiming is the suspect's vehicle was still driving around and moving around the neighborhood, and whoever did it does not have Stretch Armstrong arms. They cannot be driving around and being stabby at the exact same time. So how does that work? It doesn't. It really just does not. With these constructions, i.e., that the murder must be accompanied by acts setting it apart from the norm of murders, and that its commission manifests such depravity as to offend all standards of morality and intelligence, the aggravating circumstance contained in Idaho Code 192515F5 is sufficiently definite and limited to guide the sentencing court discretion in imposing the death penalty. Now, honestly, the amount of depravity or however heinous the crime is honestly doesn't have anything to do with guilt or innocence. That again should be something that should definitely be being considered after somebody is found guilty when it comes to finding out just how much they should be punished. And then it quotes State versus Osborne, well, cites State versus Osborne, and that one's from 1981, and then State versus Samantz from 1977. And it says, despite this ruling, the Idaho Code, and again, for the HAC states, the terms especially heinous, atrocious, or cruel are considered separately, but in combination with manifesting exceptional depravity. Okay. The terms heinous, atrocious, or cruel are intended to refer to those first degree murders where the actual commission of the first degree murder was accompanied by such additional acts as to set the crime apart from the norm of first degree murder. See, that's what I mean right there. What is there in addition to just the life ending wounds to where this would even be being talked about? Man, trial's going to be sad. Trial's going to be heavy. The statutory aggravating factor does not exist unless the murder was especially heinous, especially atrocious, or especially cruel, and such heinousness, atrociousness, or cruelty manifested exceptional depravity. It must be thought that every murder involves depravity. However, exceptional depravity exists only where depravity, see, it's changing as I'm saying it because I'm saying it too much and I'm tired, is apparent to such an extent as to obviously offend all standards of morality and intelligence. The terms especially heinous, manifesting exceptional depravity, especially atrocious, manifesting exceptional depravity, or especially cruel, manifesting exceptional depravity, focus upon a defendant's state of mind at the time of the offense as reflected by his words and acts. Other jurisdictions. In Alabama, the aggravator reads, the capital offense was especially heinous, atrocious, or cruel compared to other capital offenses. Courts in Alabama define this. I don't care. I don't care. I don't care what Alabama says. I don't care what Arizona says. I don't care what Arkansas says. I don't care what California says. I'm not reading this, guys. I'm not reading this. I don't care what Georgia says. I don't care what Indiana says. I don't care what Kansas says. I don't give a damn, a holy hot damn, about Louisiana neither. I don't care about Mississippi. North Carolina, I don't give a holy hot damn about Oklahoma neither. Sorry, not sorry, guys. I'm just meaning, like, I don't care about none of this. Pennsylvania would only matter if he committed these crimes back where he came from. Like, I don't get it. I don't understand why we're going through so many states. South Carolina, I don't give a damn. South Dakota, I don't care. Tennessee, what does she do? One for every 50 states? Are we going to get back to what we need to do? Utah, who cares? Wyoming, I don't care. Finally, back to the argument. Here we go. I don't care about none of that, guys. Like, I'm sorry. Again, you guys know the links are all in the description box if you feel the need to do that. But right now, this is a death penalty possibility case in Idaho. I don't care about other states' definitions of this word because regardless of what they're trying to do here, regardless of how I feel about the person that they actually have as a suspect right now, this is what this crime was, like I've already said. I'm not going to sit here and try to entertain even a little bitty bit something that tries to take away the severity of the situation. I don't care what the argument is or what the main fight is. I can still believe they've done a piss poor job proving to me that Bryan Kohberger is guilty and still not be okay with their arguments because they're basically trying to lessen the crime instead of prove their client innocent. And that's not okay to me. I don't like that at all. Argument. This court should strike the HAC aggravator in this matter. Actually, they shouldn't. They shouldn't. First, this court should find that the gloss placed on the aggravator by the Idaho Supreme Court was in violation of Article 2, Section 2 of the Idaho Constitution. Without this gloss, the wording of the aggravator has already been struck down by the California Supreme Court, the Eighth Circuit, and in alternate forms by the United States Supreme Court. Additionally, the saving construction does not actually appear in the ICJI for the aggravator. Separation of powers. The court in State versus Osborne, which is actually finally an Idaho case from 1981, cites Godfrey, also an Idaho case from 1980, Gregg versus Georgia from 1976, found that the United States Supreme Court had held that a statutory aggravator in a capital case can be given a limiting construction that gives sufficient guidance to the sentencing authority. Oh, it has. I love that it does that now. I don't remember it ever doing that before. Note, this is the footnote, number 1. Note that the Supreme Court, like most jurisdictions, has held that a court can give a statute of limiting or saving construction and says to see Aptheker, Secretary of State from 1964. This doctrine has its roots in either making the assumption that Congress did not intend to write a statute that odds with the Constitution or that courts should avoid interpreting statutes in a way that violates the Constitution. So either Congress wrote it that way on accident or you, as whoever is interpreting it, should stop interpreting it that way because you're wrong. Okay. Let's go back to where it was. Right here. The court has continued to rely on this precedent to uphold this aggravator. And again, they mentioned State versus Hall. However, in Verska versus St. Alphonsus Regional Medical Center from 2011, the Idaho Supreme Court reversed course on its ability to put a judicial gloss on statutes. The court held. Why are we talking about a medical case? If this court were to conclude that an ambiguous statute was palpably absurd, how could we construe it to mean something that it did not say? Okay, look, I don't really care about any of this. The crime was heinous, atrocious, cruel, evil, all the things. Just because they have to defend their client doesn't mean that goes away. The Idaho Supreme Court has therefore found that it does not have, as the federal courts in other states have, the ability to change the wording of a statute so as to save it from absurdity. It's not absurd to think that about this case. It's not. Given the court's inability to revise statutes, the holding in State versus Osborne from 1981, providing a rewording of the HAC was unconstitutional. The court also held that the terms in a statute are given their commonly understood everyday meanings unless the legislature has provided a definition. Thus, rather than the court's Osborne revision, the statute must remain as it is, with definitions as provided in the dictionary. Instead of, it is our interpretation that heinous means extremely wicked, blah, blah, blah. Okay, all those things we've already read, okay? Instead of it saying all of that, the instruction should say heinous means utterly idios, or wicked, that atrocious means horrifyingly wicked, and that cruel means willfully causing pain or suffering to others or feeling no concern about it. Feeling no concern about it? That's a mental disorder. That's a problem. New Oxford American Dictionary is where they got that from. But the court's holding, taken from Florida, clearly went beyond simply going to the dictionary. The court specifically added language stating that in addition to murder, the state had to prove additional acts setting it apart from the typical conscienceless murder and involved torture. Okay, well, they might be. It just might not have been Bryan that committed those things. Interestingly, the actual instruction adopted by the court in ICJI 1713 does away with the additional proofs set in Osborne and held to have saved the statute in Hall. The Supreme Court in Hall relies on manifesting exceptional depravity as its limiting construction. Oh, and then we have another footnote from them citing Hall again. It states, note these words actually appear within the statute and are not a limiting construction, as that term is used by other courts or even the Idaho Supreme Court in another case. Okay. The court then rejected the ruling of the Eighth Circuit in Moore versus Clark from 1990 that this language is unconstitutionally vague, relying on the ruling in Levitt v. Arav from 2004. But I don't feel like it is. I feel like this is a stupid ass argument. I'm sorry, but I do. It certainly was not considering the text of ICJI 1713, which does away with the gloss that the court found saved the aggravator, relying on the ruling of Profit versus Florida from 1976, holding that the conscienceless or pitiless crime, which is unnecessarily torturous to the victim, provides adequate guidance to the sentencing authority. Because the Idaho Supreme Court cannot change the wording of the aggravator, and because the saving construction adopted in Osborne is not even included in ICJI 1713, and finally, because the statute itself is unconstitutionally vague, no, it's not, and it's very, very relevant to this situation, this court must strike this aggravator from the notice pursuant to blah, blah, blah. Conclusion. Based on the foregoing, an argument to be presented at the hearing hereon, this court is respectfully requested to grant this motion that the HAC aggravator in the state's notice pursuant to Idaho Code 184004A be struck and the court not instruct the jury on the HAC aggravator. And then they are requesting a 25-minute hearing. I don't agree with any of this. Like I've said throughout my aggravation reading this entire document, just because I have issues believing that Bryan Kohberger is the guy doesn't mean that I'm okay with them trying to lessen what happened here. Just like this one. The motion to strike multiple victims aggravator. No. Because whoever did do this deserves the highest punishments. And the fact that it is multiple people should be considered for said punishment. This is more difficult than I thought it would be, just like emotion-wise, like taking in wise. I really didn't feel like I would have a lot of like conflictions here, but I really am like I'm differentiating between the case and the crime itself and the person that's the suspect. And it's really hard. It really is difficult. Again, this is the motion to strike multiple victims aggravator. It's only 5 pages this time. And it says this motion is made on the grounds that murders cannot be aggregated in a manner that makes the act of a malice aforethought murder aggravated. Issues. Whether multiple victims in a malice aforethought murder case aggregate for punishment purposes. I think it does because it means you're capable of hurting more than one person and not giving a shit. That definitely is valid. Okay, argument. The United States Supreme Court has held that the Eighth Amendment's prohibition against cruel and unusual punishment made applicable to the states through the 14th Amendment prohibits a state from imposing the death penalty for all but the worst crimes. Roper versus Simons in 2005 is then cited. Thus, the sentencing body must be provided with standards which will genuinely narrow the class of crimes and the persons against whom the death penalty is imposed to these particularly culpable murderers. Again, Zant versus Stevens from 1983 is cited, and Gregg versus Georgia. They've mentioned these a bunch, and Furman versus Georgia. Yeah, they mentioned those a lot. Multiple victims is, the defense acknowledges, an intuitive aggravator and one adopted by many jurisdictions. And it talks about all these other codes. It looks like Alaska, California, Montana, South Carolina, Tennessee, Texas, Utah. However, it fails to actually achieve a proper focus on the degree of the crime or crimes, and if anything, denigrates the victims? Denigrate? Criticizes unfairly or disparages the victims. So saying that there's like acknowledging the fact that there's more than one victim. No, you're out of your mind. That's not at all what that does. No. Imagine a killing that fits malice, aforethought, first-degree murder as defined by IC 18401 and 403 that somehow fails to meet any of the aggravators in IC 1925159 except multiple, i.e., a murderer with no prior convictions for murder, Bryan, did not create a great risk of death to many persons, but that's what the case is, did not kill for remuneration. I don't know what that word means. I'm not even going to sit here. Remuneration is a term that refers to the total amount of employee receives for performing a service or for being employed by a company or organization. Let's do law definition. Total compensation earned by an employee. Why are we talking about that in this? Was not committed. What? Did not kill for total compensation earned by an employee? For murder. Okay, what's the definition for murder? Murder occurs in order to receive. Okay, so like if somebody killed somebody because they wanted to be the person that got their life insurance. That. I was confused. I was like, what in the world? That don't make no sense. Okay. D, the killing was not heinous, atrocious, or cruel, manifesting exceptional depravity. E, did not exhibit an utter disregard for human life. How does a murder not, besides a literal complete accident, how does a murder not exhibit an utter disregard for human life? Come on now, was not committed while the murderer was perpetrating or trying to perpetrate arson, grape, robbery, burglary, kidnapping, mayhem, lewd conduct with a minor, essay of a child under 16, ritualized essay of a child, S, exploitation of a child, S, battery of a minor under 17, or forcible, S, that word with a foreign object. Oh gosh, okay, yeah. Did not show a propensity to commit murder. I, was not against a former or present member of the legal system. J, or against a potential witness in a proceeding. K. That's a lot. Yet, at least 2 people have been intentionally murdered. What? Oh, okay, hold on. I had to give myself a second. I had to go back because we know that's not true. We know it's 4, but they said imagine a killing that fits this. But all these things. So they're giving us an example. If a juror cannot take into account these factors, which encompass motive, method, and probability of future murders, there is nothing left. There is no way in which 2 murders can be aggregated in a way that makes the act of murder aggravated, except to resort to one of the other aggravators. See Jonathan R. Sorensen and James R. Marquardt. I guess they wrote something about capital cases in Texas back in 2002, finding that multiple victims played a powerful role in determining whether juries found a defendant posed a threat of future dangerousness in Texas. Yeah, If you can hurt one person, your future dangerousness level definitely skyrockets. But if you're doing harm to more than one person at one time, then yeah, duh, it definitely does. In point of fact, no other state but Idaho includes both a multiple murder and a propensity aggravator. And then it talks about an Alaskan code and a California code and all the other codes it talked about earlier. Texas's statutory scheme makes multiple victims a capital crime and then requires the jury to find future dangerousness before death may be imposed, thereby supposedly avoiding what Idaho does explicitly. So before Texas will consider death, the jury has to decide beforehand if the person is dangerous to the future of the people they encounter in society or anywhere else. I mean, honestly, that's pretty much how it should be. I understand the whole argument because there's no reason to talk about future dangerousness if the person is going to be put on to death. It's completely an irrelevant argument, so I do understand that. I do understand that part. Thus, the multiple victims aggravator is at best a catch-all for cases to which it applies, while at the same time violating the Supreme Court's prohibition on double counting. But see, that's bullcrap too, because you're basically trying to say that the two different people's lives being taken doesn't matter when it comes to punishment because they're just supposed to be looped in together. That's what's making it sound horrible. That's what's putting the victims down and basically making them irrelevant and you like it's nothing. Not what's happening now. I'm confused by their argument here. I feel like this is opposite of what it should actually be. Although double counting does permit the same evidence to support multiple aggravators, the aggravators must have additional aggravating evidence not included in another. Multiple victims has no additional evidence. What do you mean? Multiple victims don't have any additional evidence. Each person's wounds that are different are going to be evidence. The way that each person was attacked, the way that each person was taken away is going to be evidence. And sometimes there will be a different cause of death than there is for another victim, just depending on the wounds. And each victim is important to be identified separately. They're literally trying to take the humanity away from the case. Like, I know that there were people saying that the reason why Ann Taylor probably mentioned Bryan Kohberger having a dog that he loves and helps train was to humanize him. But that just means that they're trying to dehumanize what actually happened here with their fight. They've basically done it in every single argument so far. They're trying to take away the severity and the importance of the actual four victims, the whole reason we're here to begin with: Kaylee, Maddie, Xana, and Ethan. That's what's happening in these arguments, and it's really making me upset. Like, I know with the side that I'm on here how upset this is making me, so I can't honestly imagine what we're going to hear from the Goncalveses about this. I might actually agree with them this time around, just because I don't like how this is making me feel. It doesn't change my mind on guilt or innocence. It doesn't. But I don't like this. I just don't like this. It is simply the fact that 1 + 1 makes 2. As an aggravator, it is and was predicated on the fact that more than one victim tells us something about the killer and the killing, and that's true, hello, and what it tells us is necessarily captured in a separate aggravator. To make matters worse, what multiple victims tells us, if we take away the other aggravators, is that a single dead person is not as valuable as two. That's not true either, because plenty of people have been placed on death row for only taking a single life. So that's crap too. The United States Supreme Court has explicitly rejected scoring murder victims on a value scale. That's a damn lie. That is a damn lie. If you are a celebrity or high class, have money, know people of power, your situations are going to be handled a hell of a lot different than my situations have been handled. Okay? So that's a lie. That's a straight up lie. It cites Booth versus Maryland from 1987. Although the court later overruled Booth, it did not hold that comparing lost lives was permissible, but it barely held that as a general matter, it does not happen. Then it cites Payne versus Tennessee from 1991. However, when a legislature literally declares two are worse than one, that is precisely what happens. I'm sorry, again, two is worse than one. One is horrible. So, as horrible as one is, why wouldn't two be worse than one? I don't understand here. Okay. Not because it tells us, again, she's missing all of her endings. She's missing her EDs and she's missing her S's on almost everything. This clerk of court. This really I'm just aggravated all the way around. Not because it tells us that 2 times the pain is more pain, because it tells us a single death, no matter the pain it causes, cannot be enough. That's not what it says. That's not what it says. Again, there's plenty of people that are on death row for only taking one life. No, this is absolutely stupid. Similarly to Mr. Kohberger's objection to future dangerousness as an aggravator, the point is not so much that a jury would be wrong to consider the implication of a double or more homicide when deciding the appropriate sentence. However, if the question is what sort of circumstances elevate a particular case such that death may be imposed, the fact that there is more than one victim tells us nothing about the culpability of the offender. More information is necessary to come to the conclusion that death is appropriate. No, it's not. The fact that you're capable of such an act is enough. Okay. Conclusion. Based upon the foregoing and argument to be presented at the hearing hereon, this court is respectfully requested to grant this motion that the multiple murders aggravator in the state notice pursuant to Idaho Code 1840-04A be struck, and the court not instruct the jury on multiple murders. And notice no request for a meeting on this one. Probably because they know that it ain't going. Nah. Again, they're trying to take away the seriousness of this crime, and I'm not okay with it. Okay, so these are written a little bit differently. So this is motion to strike notice of intent to seek the death penalty, and I guess it's based on the failure to present aggravators. I'm going to let you know right now, this automatically sort of like is throwing me off because they just basically filed motions for the court to not allow all of the aggravators. But then they're going to say, now because we want all the aggravators taken out of court, now we're going to say because all the aggravators are gone, we're now going to strike for the death penalty because the aggravator is going to be taken out of court because we requested it to be taken out of court. Is that how I'm seeing this? Is that how this is working? That's what it seems like. Motion to strike notice of intent to seek the death penalty on grounds of failure to present aggravators to neutral fact finder. Okay, 16 pages. Let's see what's going on here. Now, again, he wants to strike that situation on grounds that there was no check on the decision of the prosecutor to pursue the death penalty. What does that mean? There was no check on the decision of the prosecutor to pursue the death penalty. This was going to be a death penalty case regardless of who or how many people were arrested. I'm sorry, not sorry. That's just how that was going to be. Issue. The Constitution requires a neutral fact finder to determine where the death penalty may be pursued. This process provided to Mr. Kohberger up to this point has failed to adequately protect him from being arbitrarily selected for the death penalty in violation of the 8th and 14th Amendments, in that no check was placed in the discretion of the prosecutor. The prosecutor has previously told this court, what the state is trying to do is to enforce the law that our legislature has put in place that says, in cases such as this, in facts like this, a jury is entitled to decide not only guilt but potential penalty. We are simply trying to fulfill our responsibilities under the law. To characterize it as the state is trying, is wanting, is trying to kill someone, is just simply appealing to raw emotion. It has no place in the courtroom. Did he say that? I think he probably did say that. However, yeah, look right here. William Thompson on January 26th of 2024. Okay. However, as the prosecutor knows from his own experience in refusing to pursue the death penalty in State versus Lee, the decision to pursue the death penalty falls entirely and unreservedly to his own personal decision. Now, I just want to remind you guys about a case that I really do need to do an update on. I haven't done an update on it because it got moved out of Idaho, but the Megan Stedman case. When that loser that took Megan's life was arrested, it was one life. It was a heinous act because her body was definitely destroyed. Okay, we're just going to put it like that. All right. And they instantly filed for the death penalty against him before more facts came out, and it had to be moved out of Idaho and back to Montana. So for this to sit here, these arguments at all to sit here and act like there's no reason for there to be stacked on charges or more aggression when it comes to penalty because there's more than one victim because of this death penalty thing, the way that they're trying to present that last argument and the way that they're talking about stuff now, they've done this for one person before. Now, just because Thompson decided in this case, this State versus Lee case, to not pursue the death penalty, Megan Stedman was one person. And old dude was going to get the death penalty if it had stayed in Idaho. And there was no way he was going to get out of it. Nobody was going to be advocating for him. He walked out, put his hands up and said, yep, I'm so-and-so. My girlfriend's in there. I killed her. Basically, that's what he said. Yeah. In her own RV. Drove around with her for like 21 days with her dead body. That was a death penalty case. Her argument, honestly, was invalid. And it's just aggravating me because, again, I just feel like they're trying to take away the severity of this. And I don't appreciate it. I just really don't. I just don't. Then it says to see the Marty Trillhouse, I guess, article in the Spokesman. So I guess we're going to go ahead and click on it. Spokesman.com. Huckleberry's online. I mean, is it going to populate anything? Are they supposed to be like sending me to what they're talking about? I'm not going to go looking for it. Okay. If I click on it and it's not here, then it just is what it is. And look, more here for what? Okay. There it is right there. Idaho's death penalty faces its own mortality. This was written for the Lewiston Tribune. I'm not going to read it, but as always, description box. Okay. Now let's go down here to selecting candidates for death. And it says, in Idaho, the decision to pursue the death penalty is the prosecutor's. IC 1840-04 provides the penalty for first-degree murder is death or life imprisonment, but it may only be death where the prosecutor files notice of their intent to pursue death. They did. IC 1840-04A provides the prosecutor may drop their pursuit of the death penalty at any time, and if they do so, death cannot be the outcome of the case. This is true too. The only limitation on the prosecutor's ability to seek the death penalty then is that it be a first-degree murder case and that the prosecutor can find one circumstance of the case called a statutory aggravator listed in IC 1925-159. As explained in detail in Professor Kohberger's Narrowing Death Eligibility in Idaho from 2022, due to the broad and vague nature of both what constitutes murder, really, and what constitutes an aggravator, almost every murder is eligible for the death penalty at law. Professor Kohberger and her team, is it Kohberger or Cover? I'm going to say Cover. Professor Cover and her team analyzed first and second degree murder cases in Idaho filed between June of 2002 and the end of 2019. They found that 86 to 90% of all murder convictions were factually first-degree murder cases, and that 93 to 98% of those factually first-degree murder cases were eligible for the death penalty under Idaho's scheme. In fact, the scope of Idaho's death penalty is constitutionally defective in its own right, as will be argued in a separate motion. Another one. Thus, there is no jury entitlement to the death penalty. There is only the decision of the prosecutor that sets the defendant upon this path. The consequence of placing no check on the prosecutor's discretion to seek the death penalty is a system in which geography plays the largest role in determining whether the accused will possibly be executed. What exactly are they meaning by this? No check on the prosecutor's discretion to seek the death penalty. What does that mean? There was 4 people murdered in this case. That's an automatic death penalty case. Again, I don't appreciate this fight. I don't appreciate this argument. No judge may compel a prosecutor to seek death. Alternatively, no judge may prevent a prosecutor who wishes to seek death penalty from doing so. And given the demise of the grand jury, there is no check at all against overzealous prosecutorial decisions to seek death. Okay. I can see how that's a problem for a jury because a judge can't control what's decided. Like, they can't take the death penalty off of the table because the prosecutor, once they decide, it's not up to the judge to take it off. The prosecutor themselves have to then decide that it was too much, and so they revoke it. That's the only way that it can be removed once it's there. A judge cannot then say, I don't agree with this, therefore I'm taking it away. I don't agree with that. There should be a law there. Now, I don't believe that it should just be whatever, but yeah, there should definitely be stipulations for what can be considered a death penalty case, and I think there already is. Like, I'm pretty positive there's already stipulation standards and minimums that have to be met before it's a consideration. But I can see how this is a problem in a jury trial, because if a judge was making the decision and they just don't want or don't believe in the death penalty themselves, however that may happen, they don't have to say anything or whatever about the fact that it's being presented. Even if they don't agree upon it, they can just choose not to put that in their brains whenever they're making the decision. But a judge can't be in control of that whatsoever if they feel like it's unwarranted, if it's a jury trial. So I guess I can I can understand. But again, 4 lives. This is literally trying to downplay what happened here, and it's not cute. As Justice Breyer found, geography also plays an important role in determining who is sentenced to death. I doubt that. Honestly, I doubt that. There's a mix of people everywhere, and I know some states don't do death penalty, some countries don't do death penalty, so maybe I'll agree with that just a little bit. But in the end, at the base of everything, a human that does certain things shouldn't live. Should not be allowed to breathe, should not be allowed to be around us, should not be allowed to even be in our atmosphere. And that's just the facts. Sorry, not sorry about it. So I sort of agree with that to an extent. I don't feel like I need to sit here and read all this for some reason. I don't. These arguments are very drawn out. And to me, they're not fair arguments, because I don't like the fact, like I've already said, and I know y'all are probably getting sick of it, it's downplaying the crime. And I guess that's just what I'm going to be stuck on now. Reading these is the way that it's making me feel about it, because I don't like it. I don't like it. Some studies indicate that the disparity in charging reflects the decision-making authority, the legal discretion, and ultimately the power of the local prosecutor. And then there's a book from 2013, and then another one from 2009 about something happening in Missouri, another one about Connecticut, and then another one in Colorado. All stuff that does nothing to do at all with freaking Idaho. As will be shown, the lack of a check in this discretion violates the Constitution. Not for a quadruple homicide. No. Sorry, not sorry. I'm so tired of it. B, grand jury requirement of the Fifth Amendment. The Fifth Amendment requires that a grand jury pass upon any case involving the death penalty. That right, as Mr. Kohberger has argued previously, was intended as a shield against government run-amok. And then it mentions the motion to dismiss the indictment for grounds of error in grand jury instructions, or in the alternate, to remand for preliminary hearing. And then it talks about something from 2004, and then from 2003. It was so revered by the colonists that Madison enshrined it in the Fifth Amendment, even as Hamilton argued it. We're going back in time again. Okay. Despite this, the Supreme Court in Furtado versus California from 1884 determined that the amendment should not apply to the states through the 14th Amendment. The Supreme Court in Hurtado held that grand jury requirement was simply a choice made by the writers of the federal Constitution. I'm not doing this right here. We don't have any information about the grand jury. They've tried to fight the grand jury fight. It didn't work. I don't understand the point of this argument right here because it's not specific to fact. It's not specific to case fact, to evidence, to anything. It's just a bunch of case sightings. Talking about the grand jury. And I don't understand the whole like neutral fact finder thing. Like, do they not have like shared information? Like, isn't the stuff that Butanti and whoever else is working for the defense finding also being shown to the defense? Like, I know that they apparently don't have to show all of their cards, but there can't be like any super surprise crap either. As far as I know the rules are, there can't be no like last minute running in through the courtroom doors. Oh my gosh, I've got evidence. Like, I'm sure it's happened before, but that's not how this is supposed to actually work. So the whole neutral fact finder thing is interesting because they're all basically looking in the same places. But I just don't feel the need to read all this stuff about the grand jury. And this is all this is right here. And then grand jury requirement for the 8th Amendment. They can argue whatever they want for the grand jury in this argument right here, but it doesn't mean anything to us whatsoever because we have no idea about any of it that happened. They handled so much of the grand jury stuff behind closed sessions that we don't know what the argument was. Like, yeah, cool, we're seeing this now. They're arguing it again. But the grand jury doesn't really have too much to do with the death penalty case, does it? Okay, so I went in and checked, and the grand jury indictment was filed on May the 16th. And the death penalty, the notice pursuant to Idaho Code 1840-04A for the intention to seek the death penalty came a little over a month later on June 26th. Now, the death penalty did come after the grand jury, but it doesn't take a grand jury decision in order for a prosecutor to seek the death penalty. And a grand jury decision also doesn't automatically mean that it's a death-worthy situation. So let's keep that in mind too. Okay, we'll start back right here. Though a divided court decided Furman, the basic principle that the punishment must fit the crime remains a bedrock of 8th Amendment jurisprudence. I mean, it should, though. It should definitely fit the crime. And it is for this reason that the aforementioned arbitrariness in its imposition goes beyond the issue of whether arbitrariness is but a mask for prejudice. Arbitrariness necessarily means that humans are being discarded at random. You mean like murderers do to the people that they murder? Seriously? No death penalty scheme may permit people to be killed for the same reasons it would spare another. Eye for an eye. Thank you very mucho. Okay. 2, prosecutors' discretion in selecting candidates for death. The prohibition on arbitrariness extends to the discretion of the prosecutor. Justice White wrote that the discretion of the prosecutor in deciding to pursue the death penalty is broad. Not really. They're not going to pursue the death penalty because somebody shot somebody in the leg and he's got a hobble for the rest of his life, but he's alive. They're going to seek the death penalty for something that is extreme. Come on now. Like, don't sit here and act like there's no rules to this stuff. Come on. However, he defined the permissible factors as the strengths of their case and the likelihood that a jury would impose the death penalty if it convicts. Defendants will escape the death penalty through prosecutorial charging decisions only because the offense is not sufficiently serious or because the proof is insufficiently strong. Exactly. If there's so much doubt, it's not going to happen. Now, I will say in the Scott Peterson case, There is zip, zero, zilch, nothing. There's no evidence whatsoever. It's all circumstantial, and that man was put on death row. Now, that has since been reversed, and it should have been reversed, because I don't understand how you can put somebody on death row for circumstantial cases when there's no body. There's no proof of anything besides the fact that he was a loser and a cheater and sucked as a human. That's basically all that we really know about Scott Peterson. So I really am anxious to see what happens in that case with all this new stuff happening. I really am. I am really, truly, truly interested in it. But again, let's not sit here and play like this is not a death penalty worthy case, like Anne is acting like it is, or whoever, the defense is acting like it is, because they are wrong. In other words, a prosecutor must make the objective decision that the case merits the punishment and for no other reason. Of course, that seems like that's exactly what's happening here, regardless of who was going to be arrested, no matter whether it was 1 or 15 people. This was going to be a death penalty case. Okay? Plain and simple. However, then the court held in McCluskey versus Kemp from 1987 that a prosecutor's decision not to seek the death penalty in like circumstances due to mercy could not be used to show a constitutional violation. What do you mean like circumstances? Maybe nowadays because we've seen so much insane stuff, but I don't see how whoever got arrested for this would matter. It would end up being death penalty regardless, like I just mentioned. Also, how can you sit there and say there could ever be mercy for someone that could do something like this? There is no way that there could be a like circumstance in which you could feel even a tinge of mercy. I don't like these arguments. I really just don't. The Supreme Court in McCluskey left the discretion of prosecutors to seek death undisturbed, though it provided no real assurance that prosecutors would not use this discretion in an arbitrary fashion. Of course, the power to be lenient also is the power to discriminate. I mean, because you're going to pick and choose who to be lenient with, but that should be based on the severity of the crime and nothing else. Then I guess it's going to be talking about something that discretionary justice mentions in 1973 and states, but a capital punishment system that did not allow for discretionary acts of leniency would be totally alien to our notions of criminal justice. It is axiomatic that the court and the people of our nation rely on safeguards to make our jury trial system as fair as possible. The safeguard intended to protect against the vast discretion of prosecutors is the grand jury. That's not true, though, because we even heard that there was at least 6 grand jurors, at least, that needed more information, that verbalized needing more information, and no one gave a damn. And it went the way that it went anyway. So that's also a false statement. It is not a safeguard whatsoever. As the prosecution has admitted on several occasions in this case, the grand jury played no part in the decision for death in this matter. And again, I agree, it shouldn't, but they really can't argue that it didn't have an effect on them thinking they could get away with it because there was a grand jury indictment. Because if the state would have declined the grand jury, if it would have been denied, okay, no indictment, I don't think they would go for the death penalty unless they felt like they had to save face. See, that's another reason why I have a lot of questions about the death penalty that they're like putting out here, because they put this intent to seek the death penalty out whenever some of us thought that they might actually have more than they're letting on. But as time has gone by, that is definitely not the case. They have like nothing. Like, according to people that have seen the freaking evidence, all the discovery thus far, they've got nothing. They've got a touch DNA profile that we've already gone over several cases to prove means nada. So are they just keeping it to save face because they know that they don't have enough to actually think that a jury would be dumb enough to put him on death row, and they're just going to leave it there so they look like they care and they look like it matters, like they look like they got what they need, but they really don't? Is it a front? Dangerous roulette game these idiots are playing, I promise you that. This footnote does say the prosecution has also stated several times that the decision to pursue death had not been made at the time, but this is untrue. The prosecution informed the defense after it learned of the indictment that it used the grand jury, at least in part, to prevent any claim that the death penalty could not be sought without an indictment. So that's something that they're claiming for this case specifically? Or are they mentioning that about this U.S. versus Singer? This doesn't say anything about Idaho, so I don't even know at this point if they're talking about this up here or the actual case, because, they're talking about everything else but case specifics. So that's awesome. Number 3, the grand jury as a check on the prosecutor's death decision. That's probably supposed to have been bolded. Anyway, since 1962, the Eighth Amendment to the United States Constitution has barred states from imposing cruel and unusual punishment where the state failed to follow procedure. And then it cites Robinson v. California from 1962. This is because when the punishment of death has not truly been earned, it is cruel. Whoever did this earned it, sweetie, I promise you. Thus, the United States Supreme Court held, death, in its finality, differs more from life imprisonment than a 100-year prison term differs from one of only a year or two. Well, no shit. Because of that qualitative difference, there is a corresponding difference in the need for reliability in the determination that death is the appropriate punishment in a specific case. In this, it is. In several cases, it definitely is the appropriate punishment. There is no other punishment but that. Sorry, not sorry. Then it cites Woodson versus North Carolina from 1976. Since 1972, states have been required to find ways to ensure that the death penalty is being imposed in a manner that is not freakish or wanton. I'm sorry, but if you can take 4 people out with a knife, it's not freakish nor wanton. You're freakish or wanton. This is a stupid argument. The vast majority of decisions followed that have been concerned by the process by which a defendant is chosen for death have focused on sentencing. It cites Gregg versus Georgia from 1976, sentencing scheme involving bifurcated hearing, aggravating and mitigating factors to be found by jury found constitutional. Then it mentions Woodson versus North Carolina from 1976. Didn't it just do that? Yeah, up here. And then Profit versus Florida from 1976. Aggravating circumstances provided adequate guidance as interpreted by the Florida Supreme Court. Again, I don't care about any of the other states. Okay, we have Florida. We have Ohio. We have Georgia. We have Oklahoma. We have stuff that doesn't matter. California. Again, why are we talking about stuff that's not going to matter in Idaho? Pennsylvania. They're basically just putting the exact same cases in here, I think, that they were talking about in the last one. I don't care about what all these other states are talking about. Nothing that these other states are doing is going to do anything to what happens to this case because it's being held in Idaho. This is what lawyers get paid to do, just jumble up a bunch of boo-boo nonsense together and make it look complicated when it doesn't need to be. These opinions essentially hold that to pass constitutional muster, a capital sentencing scheme must genuinely narrow the class of persons eligible for the death penalty and must reasonably justify the imposition of a more severe sentence on the defendant compared to others found guilty of murder. However, ensuring fairness and due process in death cases requires going beyond the sentencing to the safeguards of the proceedings. Prior to Furman, the Supreme Court had held that the 14th Amendment required additional process in capital cases. In Powell versus Alabama, again, Alabama, and then instead of imagine a case where 2 people died, like they said earlier, this is different where it says, let us suppose the extreme case of a prisoner charged with capital offense who is deaf, dumb, illiterate, and feeble-minded, unable to employ counsel, all this crazy stuff. We're not going to talk about something that has nothing to do with this because that's like literally the opposite of everything we've heard about Bryan Kohberger. Why are we talking about irrelevant things? We're just going to go down to the conclusion. Okay. Conclusion. This court must find that permitting the prosecutor to sit in the place of the judge or jury and decide that death should be a permissible penalty in that matter is unconstitutional. I don't agree with that. Just because it's on the table doesn't mean it's going to happen. It's up to the jury to decide. The lawyer, the prosecutor, is not sitting in the place of the judge or the jury by saying that he or she thinks that the crime is worthy of the death penalty. It's not until that judge or that jury makes that decision that it then becomes important. Just because they say, hey, we think it's severe enough that we want to put it on the table because we believe this person is not needing to breathe. They're not taking the place of judge or jury. They're just asking the judge or the jury that makes the decision to know that it's a possibility. That's all that it means. That's all that it means. The decision as to whether a matter is in fact a capital be checked. What in the shit? Again, does not know what she's doing. The decision as to whether a matter is in fact a capital be checked by a neutral decision maker. I feel like there's multiple words missing there. This clerk of court definitely needs to get her ish together. Like, I'm not kidding. I'm going to file a legit complaint. Like, I'm not kidding. I'm sending some emails. This is ridiculous. Unprofessional. I can make mistakes. I'm just a YouTuber out here trying to read this mess. This is legitimate official documentation. She gets paid a salary. She is a state government employee. She's messed up I don't even know how many times. Anybody keeping tally? I know some of y'all are. Tell me in the comments. This court should so find and strike the notice pursuant to Idaho Code 194004A in this matter. This one they want a hearing for, but the one to make it to where, just because there's more than one death doesn't matter. They don't want to talk about that. Or did she forget to put that in there too? Oh, hell no, we not. This is the motion to strike state's notice of intent to seek death penalty on grounds of vagueness in balancing aggravators and mitigators. And this damn filing is 143 pages long, and I'm not doing this. I am going to skim through it here for a second, but I am not going to read this because unless there's actually something in here that actually matters to the case, this entire 143 pages is useless and irrelevant because we already read through this exact same stuff in these other documents up here. So I'm going to skim and I'll be back when it's important. So this first part's really just talking about how lethal injection is horrible and the history of the types of executions that Idaho has dealt with. Like, it shows right here, issues, constitutional limits on manner of execution, the history of executions in Idaho, lethal injection in Idaho is not viable, and then the firing squad is not and was never constitutional. Okay, well then why do they just bring it back? That's all this is talking about. It's talking about the last time there was some sort of issue very recently with a man that they tried to put to death in Idaho. And apparently it went like really, 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 really wrong. Now there is still stuff going on. As you can see, I just typed in failed Idaho execution. And as of 1 hour ago, there was an article about the situation. Idaho halted an execution of serial killer Thomas Eugene Creech on Wednesday, not this past Wednesday. This happened. When did this happen? This happened not very long ago. Let me go ahead and actually click on this. February 28th. It happened earlier this year. Okay. The medical team members failed to find a vein where they could establish the IV line in order to put in the lethal injection. Okay. That happened this year. So I understand why they want to argue this argument. He tried to have his execution just completely like null and voided, and that's being dismissed. They're like, nah, bro. So I don't know if they're going to try to do it the same way again, if they're going to go firing squad this time. I don't know. Super crazy. I don't know how that's going to go, but I do understand why they want to argue it. I do. I get it. But then they go into talking about the firing squad situation. And it says this brings us up to this year when Lamont Anderson, now the lead deputy attorney general for the Capital Litigation Unit, returned to the legislature to ask for the firing squad back. That's the reason why the Goncalves family wears these shirts. Lovely, isn't it? Judiciary Rules and Committee Minutes, March 13 of 2023. And there is an entire website right here where they had the meeting about the firing squad. And that's all this portion is about. And then it has more information about firing squad stuff. And that's all this is. I don't want to read all this stuff. I really don't. I don't really care about this stuff. Guys, I care about case facts. Like, I'm all about getting into the documents, but I want documents about what really happened. I believe in the death penalty. There's nothing that's going to change my mind on that. Now, I do know that they need better practices, and I know there has been people put to death that were completely innocent. I'm not stupid. I will admit that is a thing that happens, but that doesn't mean that there are people that deserve to keep on living just because a few mistakes were made. No. I'm sorry, no. This is a death case, regardless of who did it. Regardless. As long as they're the ones who did it. That's the problem, though, isn't it? As long as they're the ones who did it. Now, they're also talking about the injections again right here, and they're talking about the different that were used. Sodium pentothal and pentobarbital. Different things like that. It's just a bunch of stories. It's a bunch of stories about all of those things, and it's in different states and stuff too. But I do disagree with this statement right here. It says the botched legal injection of Thomas Creech in February of 2024 demonstrates that even with lethal injection are obtained, lethal injection is not available in Idaho. Just because something crazy happened to where the guy's vein couldn't get actually like penetrated for the IV to be entered does not mean at all whatsoever that lethal injection is not available in Idaho. How does that equal that? I'm sorry, but that doesn't make any sense literally at all. Literally at all. But this is also apparently the claim that they're using when it comes to why the firing squad was readopted. Whatever. I think it was going to happen anyway. Now, there's some stories in here. I'll read this one because it's got my attention, but it's a death story. So if you don't want to hear this, skip somewhere, but this is a death story of an execution. This is in 2010. Ronnie Lee Gardner volunteered for the firing squad in Utah. June 18th of 2010. When a prison official opened a curtain to reveal the death chamber to witness early Friday, convicted killer Ronnie Lee Gardner was already strapped to the execution chair. His eyes darted around the room at a prison in Draper, Utah, but he appeared calm, even at peace, witnesses said. This was a stark contrast from a troubled life marred by drugs, SA, and indiscriminate violence. Asked by a prison official if he wanted to say anything, Gardner simply responded, "I do not, no." A black hood was slipped over his bald head, a small circular taget? What does that even mean? I don't know what that is. It thinks I'm saying target with an accent. Medical device? Again, it thinks I am talking about Target. This is showing me a hearing aid. Did this woman just write a word in here that doesn't exist? This clerk of court? Or did she copy and paste something from somebody that doesn't exist? If any of you that work actually in a hospital, like doing things with patients, like this sounds like this would be something like you would hear. It sounds like the stethoscope. Is that what that little circular thing is on the stethoscope? Because you'd think Google would be able, or whatever, Bing would be able to find the word. That's very kind of strange. Okay. A barely audible countdown was interrupted by two loud bangs in quick succession. It was 12:15 a.m. After a quarter of a century on death row, Gardner, 49, they've mentioned this case, they've cited this case, became the first man to die by firing squad in Utah in 14 years. He clenched his fist and then let go. Radio talk show host Doug Fabrizio, one of the small group of witnesses, said, then he clenched it again. A medical examiner checked Gardner's pulse on both sides of his neck. When the black hood was lifted to check Gardner's pupils with a flashlight, his ashen face was briefly revealed. He was pronounced dead at 12:17 a.m. So the two bangs went out at 2:15. He clenched his fist, let go, clenched again, and it took like 2 minutes for him to die, I guess. That's a long time. At exactly midnight Friday, the inmate who spent more than half his life behind bars was awakened from a nap for his execution. He was escorted to the nearby execution chamber where he was strapped to a metallic winged chair. He wore a dark prison jumpsuit and no shoes. Did I say shoot? Jumpsuit. I've been talking for too long. It is now 12:40 a.m., guys. I'm just letting you know where I am in recording this stuff. The chair was raised on a small black platform like a stage. Relatives of his victims and members of the media witnessed the execution in separate rooms nearby. A team of 5 anonymous marksmen armed with a .30 caliber Winchester rifle standing just 25 feet away behind a brick wall cut with a gun port aimed their weapons at Gardner's chest. The Utah law enforcement officers volunteered for the assignment. One rifle was loaded with a blank, so no one knew who fired the fatal shot. I heard that's what they do, yeah. Gardner repeatedly rubbed his left thumb and forefinger moments before the shooting. So this was before? Why did they start there? Jesus. The rifles exploded and 4 bullets perforated his heart and lungs. The straps held his head up. A metal tray beneath the chair collected his blood. Sandra Yee, a reporter with KSL TV in Utah, said Gardner fidgeted even after the barrage of gunfire. When he was shot, some of us weren't sure if he had passed away because we could see movement, she said. He had his fist clenched and we could see his elbow move up and down. Cheryl Worsley, a reporter with KSL News Radio in Utah, described the moments after the execution as disturbing. He moved a little bit, and to some degree that bothers me, she said. To some degree that mirrors the last few weeks of his life because he was fighting to stay alive the last few weeks, and that seemed to continue on. Prison officials said Gardner spent his final hours sleeping, reading the spy thriller Divine Justice, and watching the Lord of the Rings film trilogy. He also met with his attorneys and a Mormon bishop. He appeared relaxed. He had fasted after eating his last requested meal, steak, lobster tail, apple pie, vanilla ice cream, and 7-Up 2 days earlier. He was at peace, his attorney Tyler Ayers told the Salt Lake Tribune. He even laughed a few times, and that helped put me at ease. Well, yeah, you spend 25 years knowing that you're going to die. You probably come to peace with it. You have plenty of time to. Plenty of time. Outside the prison, members of his family, some wearing t-shirts displaying his prisoner number 14873, gathered to pay their respects. They were joined by dozens of death penalty protesters. Around the time of the execution, family members cranked up a car stereo playing Lynyrd Skynyrd's Free Bird. He didn't want nobody to see him get shot, said Gardner's brother, Randy Gardner. I would have liked to be there for him. I love him to death. He's my little brother. Now, it goes on to talk about how the Utah people that killed the Ronnie guy, they made like some sort of commemorative coin. That's weird. That's not cute. That's really not cute at all. But then they want to sit here and compare a hanging of 1957 to what happened to Gardner with the pew-pewing, okay? And the whole thing about coins being minted is odd. I don't understand that. I highly doubt they would make a coin about Kohberger if that's how this went. That's just strange. Anyway, this entire document is just stories about different times that firing squads or injections or anything else has been happening here. That's basically what this is. Okay, then it says, we're finished up right here because it looks like it ends actually on page 16, and then it goes into exhibits, and this is actually minutes of a case from back in 1978. So I guess all of the cases that they talked about, they have stuff in here. Because this is a whole nother exhibit. See Exhibit B? But these have nothing to do with the Idaho case. This has literally nothing to do at all with the case in question. This is all stuff that happened in other cases. Different years too. 1978, 1982. That's another one from 1982. See, it's all stuff to do with other stuff. Yeah, it's all the stuff they were talking about previously. But we'll go up here and we'll finish this down to the conclusion. Dang, this thing is big. But I mean, this really isn't like an argument they can really make because Idaho's courts have already brought back the firing squad. They're not going to all of a sudden change their mind because she's arguing it. It happened broadly. It's not going to change just because of the case. I highly doubt it's going to do anything. Okay, conclusion. Based upon the foregoing and argument to be presented at the hearing hereon, this court is respectfully requested to grant this motion that the state's notice of intent to seek death penalty be struck completely. The court seat a jury which is not death qualified. The court preclude the admission of any evidence of aggravating circumstances during the trial of the case, and a court not instruct the jury on any aggravated punishments. And I'm just going to go all the way down just to see what it's the last one. Yeah, and see, this is Barbara Wolf. That's the lady. That's the affidavit of Barbara Wolf. She's the one that we talked about earlier. The one that's from Florida. So I don't know if that's supposed to be in here, honestly. Was this supposed to be like a separate thing? Affidavit of Barbara C. Wolf, state of Florida. I'm an adult over the age of 18. Yeah, this is just like a summarization. And then it talks about the firing squad. And okay, we'll read this part because it's about the firing squad directly. And I think this is most likely what she's going to be talking about too in court, I'm going to assume. It talks about, well, I actually don't want to read it because there's a bunch of words in here that I'm already going to have to go in and edit out, like take away the vocals on some of these words because I'm saying words on here way too many times that YouTube is going to do some crap to my channel. So I'm going to have to go in here and like mute out like when I say certain stuff because you are only allowed so many red flag words. Stupid YouTube. Anyway, this is talking about all the problems with failures. This is the same argument, but it's coming from this MD. And I will just assume we're going to hear about this again all in court. Okay, this is 130 pages, and it is the motion to strike state's notice of intent to seek death penalty on grounds of contemporary standards of decency and memorandum in support of motion. Decency. Okay. More Americans believe the death penalty is applied unfairly than fairly, and they have some poll here from 2023. I mean, I'm not going to go through all this either. I have my reasonings for feeling how I feel. I know a lot of my viewers don't agree with the death penalty. That's fine too. That's totally fine too. But this is insane right here because it's already a summary of the argument. What's happening here? Oh, okay. So this actually looks like it's all the same argument as the previous one. Look, right here. About Thomas Creech. This is pretty much the same stuff. Okay, well, we'll start. Okay, summary of argument. Idaho's legislative and judicial construction and application of capital punishment violates the prohibition against cruel and unusual punishment contained within Article 1, Section 6 of the Idaho Constitution and the 8th and 14th Amendments to the United States Constitution. Punishment which does not comport with the evolving standards of a modern civilized society is cruel and unusual. Well, I think civilized people are kind of tired of inhumane people. I'll say that. In recent years, a national consensus in opposition to the death penalty has begun to emerge. I mean, they're not wrong. I know there's some countries that just don't do it at all. I understand that. But is that going to be their entire argument here? Because I don't want to read all of that. That's an argument that people have on a daily basis on Twitter. So if I want to have this argument, I'll go have it over there. But that's basically what this is. In the vast majority of the United States, a death penalty sentence or executions are rare events, and they are becoming increasingly rarer each year. So she's basically arguing, well, it's not even her. This is all Logsdon signing all this stuff. But they're basically arguing that because it's in such a decline, it's just not the thing to do anymore. Therefore, you just shouldn't do it. I'm sorry. Whoever did this crime deserves the death penalty. I mean, it's really just that simple. It for real is just that simple. But I have a feeling that's what this entire thing is about. And then it talks about state changes, and it's about other states. So it's almost like the whole argument is all these other states are doing this so that we should do it too. Now, it does lead back to what I said that me and Ariel were talking about in the car, that as a country, there's no reason for certain things to be different in each state. Just like this. Murder stipulations, death penalty stipulations, and stuff like that, okay, should be blanket. Should be blanket. It definitely should. Now here it goes again with public opinions, international communities. Okay, like I said, there are countries that even put like people that do things to children in facilities where they're still allowed to leave during the day and walk amongst normal ass people and then come back and sleep in their jail, you know, the way that Epstein was allowed to do. We all saw what ended up working out with that. All right. And there's some countries, that's how their prison system just is. They get to live in something that looks normal. They get to wear normal ass clothes. They're basically just on some sort of like crazy ass house arrest. It's not actual prison. They're allowed to talk to family. They're allowed to have friends. They leave to go to work every day. They collect a paycheck. They're just watched. These are murderers. These are people that killed people and have no remorse for it. These are people that did things to children because the country works that way. I be damned. I be damned. Okay. Let's see. I'm not seeing anything else. This is talking about human rights. International Covenant on Civil and Political Rights. I'm not going to do all this. This is a lot. There's a lot of document drops. Not like document drops, that's the wrong word for it. There's a lot of links to a lot of different articles. Now, this is something about the Middle East. This is another thing about the death penalty, something about the UN Human Rights Council. And then we talk about religious organizations that are against the death penalty. There's a lot of stuff in here just about like how different societies, different countries, different religious sects and all that like oppose it. But that doesn't have anything to do with Idaho. I mean, it really just doesn't. Conclusion. Idaho's capital sentencing scheme does not comport with contemporary standards of decency. It's not trending to put somebody to death, is the argument. Therefore, constitutes cruel and unusual punishment. Because Idaho's capital sentencing scheme does not comport with the evolving standards of a modern civilized society, and Idaho is endeavoring to have Mr. Kohberger sentenced to death, Idaho's capital sentencing scheme violates the 8th and 14th Amendments to the United States Constitution and the same articles. In the same Article 1, Section 6 and 13 they always talk about. Based upon the foregoing and argument to be presented at the hearing hereon, this court is respectfully requested to grant this motion that the state notice of intent to seek death penalty be struck, the court seat a jury which is not death qualified, the court preclude the admission of any evidence of aggravating circumstances during the trial and this case, and the court not instruct the jury on any aggravated punishment. Again, the same stuff. Do they want a meeting? Oh, no meeting. Now they have Universal Declaration of Human Rights from 1948. 1948? It's ridiculous. Okay, what is this? This looks like it was written back then, too. Look how old this looks. 1966. So that's the UN, the United Nations thing. And we're not doing all this. Wow. Different treaties for different things. really think the judge, I'm sorry. I'm going to go ahead and just say it now. I was complaining last time because I was like, if we can read all these documents, why didn't Judge read all these documents? I am not about to read all this shit, okay? I'm not about to read all this shit, and I don't expect Judge to want to read all this shit either. He's, for real? And are they going to expect, like, him to take this seriously, to sit here and read every single word of all these articles? Every single link to every New York Post article, and really, like, this is wildly a lot. This is wildly a lot, and I find it like extremely unnecessary. There's ways to argue things that make better sense than how the hell this system has been implemented, because this is stupid. Now they want to argue international law. Are we for real? Motion to strike states notice of intent to seek death penalty on grounds of international law and memorandum in support of motion. And this hoe is 481 pages long. Have y'all lost y'all's ever loving minds? Idaho's death penalty procedure violates the provisions of international treaties and the fundamental precepts of international human rights. I am not doing this. I'm not doing this. And it's the same stuff. Same stuff. I mean, more stuff. Look at this, guys. I mean, are these articles that they put together to argue for every single death penalty case? Like, I'm really wanting to go back in and pull other death cases that this team has worked on to see if they just use the same blanket boo-boo every single time and just add in things that are relevant to the day. Like, they probably have all these articles just in a folder somewhere and says death penalty, motion for this, add this article to this one. Because this is crazy. 481 pages. And it's all cases that have nothing to do with Bryan Kohberger, have nothing to do with the Idaho 4 case, have nothing to do with factual information. What is this? I need to make sure of something real quick, because this is Idaho, but what the hell is this? Okay, this is a capital case. Not this capital case. This is something from 1984. Like, unless you're going to quote me a case in Idaho where somebody killed 4 people, these arguments are pretty much just... 64 pages for what? Motion to strike state's notice pursuant to Idaho Code 184004A on grounds of arbitrariness. The decision to seek the death penalty for Mr. Kohberger violates the requirements of the 8th and 14th Amendments. It's the same thing all over again. Okay. Background. Okay, yeah. Okay, this one now has some case facts. Let's see what it has to say. Background. On December 29th, 2022, the state filed a 5-count criminal complaint charging Mr. Kohberger with 4 counts of first-degree murder pursuant to all of those codes and 1 count of burglary. The complaint alleged that Mr. Kohberger did willfully, unlawfully, deliberately, with premeditation and malice aforethought, and murder Madison Mogen, a human being, by stabbing Madison Mogen, from which she died. It further alleged the same as to Kaylee Goncalves, Xana Kernodle, and Ethan Chapin. On May 16th of 2023, the state filed an indictment with the same charges against Mr. Kohberger. On June 26th, these are the dates I showed you guys these documents. It's probably been a good 2 hours at this point. On June 26th of 2023, pursuant to Idaho Code 184004A and 192515, the state filed a notice pursuant to Idaho Code 184404A indicating it intended to seek the death penalty. The notice pursuant to Idaho Code 184404A alleged as aggravators that Mr. Kohberger committed the murder at the same time, that either murder was especially heinous, atrocious, or cruel, manifesting exceptional depravity, that by the murder or the circumstances surrounding its commission, Mr. Kohberger exhibited utter disregard for human life, that either murder was committed in the perpetration of or attempt to perpetrate arson, R-word, robbery, burglary, kidnapping, or mayhem, and or that Mr. Kohberger, by his conduct, whether such conduct was before, during, or after the commission of either murder, has exhibited a propensity to commit murder, which will probably constitute a continuing threat to society. That is not just for Mr. Kohberger, that is for anyone who is involved in this situation, whether it be him or anyone else. Let's just make it clear. I understand he's the one in the hot seat right now, but this would be how this would be going regardless if it was him or not. We need to keep that in mind here. Then it wants to go into the argument talking about how arbitrariness in the selection and imposition of the death penalty is cruel and unusual, and continues the same argument we've already gone over about 15 times now about how the Idaho's death penalty scheme fails to narrow in a constitutional adequate way the class of persons eligible for the death penalty, and I don't agree. I'm reading everything that I need to read, and I don't agree with this argument at all. And these are all the same cases, Zant, McCluskey, all of these cases that we've already talked about. Georgia stuff about different states. See? Okay. Idaho's capital punishment laws failed to narrow the types of murder that qualify for the death penalty. Sweetie, this was 4 people with a manual weapon, apparently. It constitutes it. Again, regardless of who, it constitutes it. Okay. Now this says there are 11 statutory aggravators outlined in Idaho Code 192515. Okay, but that doesn't tell me nothing about this case. And now here we go with Professor Cover again, with the exact same argument again. Again with State versus Hall, based on geography. See, this is the exact same argument over and over and over. This is something that happened in 1997, so this isn't even a footnote. That's important. This is just crazy. It's all the same argument, guys. It really is. Like, again, it will be there for you to go and look at if you so choose to. But this all feels like the same stuff. Idaho's death penalty statute failed to genuinely narrow the class of death-eligible murderers in violation of the 8th and 14th Amendments to the United States Constitution, as well as Article 1, Sections 2, 6, and 13 of the Idaho Constitution. Was Sections 2 missing from the last one? Wouldn't surprise me with this clerk of court. Under Idaho's death penalty scheme, there is no meaningful basis to distinguish the cases in which the death penalty is imposed. Idaho's scheme defines death eligibility so broadly that it creates a greater risk of arbitrary death sentences than the pre-Furman death penalty schemes. Recall that the United States Supreme Court held that Georgia's scheme was unconstitutional when 20% of those who were convicted of murder received the death penalty. Idaho's rate of handing out the death penalty stands at 3%. Well, if Idaho only does this to 3%, then I'd say they've got a pretty good head on their shoulders when it comes to the standard, right? Of what belongs at that level if it's only at 3%, because that ain't nothing. That ain't nothing. Conclusion. Based upon the foregoing, an argument to be presented at the hearing hereon, this court is respectfully requested to grant this motion that the state notice pursuant to Idaho Code 184004A be struck. The court seat a jury which is not death qualified. The court preclude the admission of any evidence of aggravating circumstances during the trial of this case, and the court not instruct the jury on any aggravated punishment. No meeting requested. Now we have exhibits, and this is narrowing death eligibility in Idaho, an empirical and constitutional analysis. This is what was written by that cover lady that they've talked about in pretty much like every single filing. So they just took a bunch of information out of her book and it put it in here with a whole bunch of statistics. Yeah. That's all this is. What is this right here? Oh yeah, this is a different case. This is a different case. Okay, see? What was the point in this? Why are you showing me this? I mean, this is literally saying, this is just another thing for another case saying that they intend to seek the death penalty for this situation. I don't really see what this has to do at all with this case. Okay. It is 1:05 a.m., guys. We've got two left. Okay, this one is 33 pages, and it says motion to strike the death penalty on grounds of state speedy trial, preventing effective assistance of counsel. What? He waived his right to a speedy trial. And are they trying to say that Ann Taylor is ineffective? I'm so confuzzled. Okay. Comes now Bryan C. Kohberger, by and through his attorneys of record, and hereby moves this honorable court for an order striking the state's notice pursuant to Idaho Code, blah, 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 blah. Okay. On the grounds that Idaho's statutory and constitutional guarantee to a speedy trial prevents effective assistance of counsel in death penalty cases. Okay, but he waived his right to a speedy trial. So why are we arguing this in a case where the speedy trial right was waived? Idaho requires all criminal defendants to be brought to trial in 6 months from the arraignment on an indictment pursuant to statute and its constitution. I'm not going to argue. I got interested in what was happening here until now. Until now. None of this matters to me. I'm going to read this, but I'm telling you right now, this is useless. He waived his right to a speedy trial. Therefore, this argument is null and void. It really just freaking is. On November 13th, 2022, law enforcement found the bodies of Maddie Mogen, Kaylee Goncalves, Xana Kernodle, and Ethan Chapin. On December 30th of 2022, law enforcement arrested Mr. Kohberger at his parents' home in Pennsylvania. Mr. Kohberger's current counsel filed for a limited appearance the same day. His first appearance in court in Idaho was January 5th of 2023. On January 12th of 2023, Mr. Kohberger filed a notice of appearance, request for timely preliminary hearing, motion for bail reduction, and notice of hearing, which contained a demand for speedy trial pursuant to 6th and 14th Amendments to the United States Constitution. Cool. He waived it later. While Mr. Kohberger prepared for a preliminary hearing, the state convened a grand jury on May 12th, and by May 16th, it had an indictment for Mr. Kohberger on 4 charges of murder in the first degree and a count of burglary. This court arraigned Mr. Kohberger on May 22nd of 2023. On May 23rd, 2023, pursuant to Mr. Kohberger's right to a speedy trial, this court set Mr. Kohberger's jury trial for October 2nd of 2023, a mere 10 months from his arrest. On August 23rd, 2023, Mr. Kohberger waived his right to a speedy trial in order to secure his right to effective assistance of counsel. Now, I'm going to say something right now, Miss Taylor. Let me tell you something. Even though I know you're never going to watch this, I'm going to tell you something anyway. You're not about to sit here and be a freaking hypocrite. I promise you not on this channel. You're not. You sat there just like everyone on the other side saying that you would have been totally fine with the house being destroyed at that point. Okay? You came out just like they came out and said that you had all the evidence you needed, that there was nothing else in the house that was needed, that you've got everything. And Bryan apparently agrees. So how are you going to sit here and try to claim anything, when it comes to there being a problem with the if of us having a trial of any sort, whether it be preliminary or whatever, way back then, before he waived his right to a speedy trial? How dare you even think you can come out here with that argument whenever you were in just as much of agreement on the boo-boo as the state was? See, I said something about this. I said, are they going to try to act like the house getting demolished and all these things happening are proof of ineffective counsel? And it sort of sounds like that's what they're trying to do here. But you, Miss Taylor, Mr. Logston, all of you, y'all were all in agreement with this bullshit. You all told the public you had everything you needed. Argument. Idaho requires all criminal defendants to be brought to trial in 6 months from the arraignment on an indictment pursuant to statute and its constitution. Why were y'all not arguing this stuff before? And again, he waived his right to a speedy trial. He waived it. And whenever there's a grand jury indictment, that resets a bunch of stuff. Now, granted, I don't agree with the grand jury indictment. You guys know that. I would have preferred the preliminary hearing because then we would have actually had some case fact out here. We wouldn't be in this stupid dumpster fire of a mess. We wouldn't. But he waived his right to a speedy trial, and his very own team was okay with the biggest piece of evidence being completely destroyed. I'm not going to sit here and feel sorry for you now. You agreed to it. I'm going to rip apart your little reverse Uno card you're trying to play right now, because no. Just no. It's going on as statutes that don't even mean anything to me, because he waived his right to a speedy trial. I don't understand how they can argue this. I'm really not going to read all this, guys. I'm sorry. If this is where y'all get off, if y'all haven't gotten off the video by now, with as long as this damn thing is, this might be where you get off. But look right here. Again, repetitive. In the end, it was the geography of our state that was to decide the issue. The Idaho Constitution guarantees a speedy trial except where there is good cause for a delay or the request for postponement came from the defendant. He waived his right for a speedy trial. So why are they arguing this? This is annoying. And it's other cases that have nothing to do with anything. Okay, well, I guess this is their argument. A defendant in Idaho can never request additional time without losing his right to a speedy trial. Okay, but if you're trying to say that speedy trial is 6 months, how the hell are you going to sit there and request more time without losing your right to a speedy trial? Because if speedy trial is within 6 months and you yourself are requesting more time, then that automatically takes you past that deadline that would consider it a speedy trial. So yeah, you can't, because you just can't in general request additional time without losing your right for a speedy trial. That's just kind of like hand in hand. That's hand in hand. But again, Miss Taylor, y'all agreed to this mess. You agreed to this mess. Backtrack your boo-boo now. This is insane. A capital case cannot be prepared in 10 months. Miss Ma'am, we hit in 24. We hit in 24. In 2. What do you mean? Again. Okay. Put simply, so long as Mr. Kohberger's execution is a possible result in this case, the state of Idaho must take basic, if not extraordinary, measures to protect his constitutional rights. You know, which is true that they do a whole lot more for you, like the state legally does, whenever you're on death row, because that was one of the things I learned in the Scott Peterson case, that whenever his death row conviction got reversed and it turned into life, that a bunch of his resources disappeared. And that's actually why the LA Innocence Project ended up taking on the case, because he lost a bunch of his state-funded resources when he got taken off death row. I didn't know that was a thing. No clue. Stuff about Oklahoma and a bunch of just case stuff. Idaho cannot force a defendant to choose between his rights, but you did. Y'all chose the right for him to not have all of his evidence presented because y'all were okay with the house getting destroyed. Now, granted, I understand that if he didn't do it, there's nothing in there that would help or hurt, but it would help the case in general if people could go in there and do more work, if the jury could see things, if things could make more sense because it wasn't just an empty field now that we're told to imagine about. It's just dumb. All I'm saying is he waived his right to a speedy trial, so I feel like this argument is null and void, and I don't understand why she's arguing it. I just don't. Based upon foregoing, an argument to be presented in the hearing hereon, this court is respectfully requested to grant this motion that the state's notice of intent to seek death penalty be struck, that they do not seek, it's all the same. But no, no meeting again. What in the world? Certain public offenses, 1887 revised statutes. 1887. Something from 1980. This kind of stuff is so stupid to me. I'm sorry, but not sorry at the same time. It's just like I hate the medical field because of how stupidly complicated they make things for literally no reason. All right? They do the exact same thing here. They do the exact same freaking thing. They throw all this stuff in there for what? The only thing that matters is the facts. Why are we having to talk about shit from back in 1887 about something that happened in 2022? Okay, guys, last one. And it's only 9 pages, so I'm going to go ahead and do this right and read the whole thing. We're almost there. Motion to strike, utter disregard, aggravator. Again, I don't agree with this because the case should not lose its relevance and importance just because of the argument at hand. We probably should have read this one before. I feel like it was out of order. It was out of order. That's fine. Okay. Comes now Bryan C. Kohberger, by and through his attorney of record, hereby moves this honorable court for an order striking from the state's notice pursuant to Idaho Code 184004A, the allegation that the murder itself or by its circumstances showed an utter disregard for human life. It did. This motion is made on the grounds that this aggravator is unconstitutionally vague and fails to narrow the class of eligible candidates for death. That's crap. That's crap. Y'all know damn well that that's exactly what this case is. Now, they're just the same things. Gregg versus Georgia, Furman versus Georgia. They're basically using the exact same cases over and over and over. There they are again. Lowenfield and Phelps. There's Zant one more time. There's Gregg again. See, it's all the same. And look right here, this exact same thing. The legislature may itself narrow the definition of capital offenses as Texas and Louisiana have done so that the jury finding of guilt responds to this concern, or the legislature may more broadly define capital offenses and provide for narrowing by jury findings of aggravating circumstances at the penalty phase. It's all the same stuff. However, in Mr. Kohberger's case, the charges are premeditated murder, not a murder with any sort of special circumstances. That's true, too. But they said it wasn't a crime of passion. I feel like whoever did this, it would have to have been premeditated. At least a portion of it would have had to have been premeditated. Whether it be a few days, a few weeks, or just a few hours. But it definitely was, in my opinion. Thus, in this matter, the aggravating circumstances perform the narrowing function. Then they go on to State Hall. That all having been said, the aggravating circumstances in this case must meet 2 requirements. The circumstance may not apply to every defendant convicted of murder, and it must apply only to a subclass of defendants convicted of murder, genuine narrowing, and the circumstances must not be unconstitutionally vague. We read that before already. Now we're going into the vagueness thing. We're not about to do the legislative history or the judicial gloss again. We've done that already. We're not going to do this either because this is the exact same argument from the HIC document. It's the exact same fight, exact same cases. Argument. This court should strike the utter disregard aggravator in this manner. First, this court should find that the gloss placed on the aggravator by the Idaho Supreme Court was in violation of Article 2, Section 2 of the Idaho Constitution. Without this gloss, the wording of the aggravator has already been deemed unconstitutional by the Idaho and United States Supreme Courts. Additionally, the saving construction does not actually appear in the ICJI for the aggravator. Now, I do agree with that if what they're claiming up here about it being the meditated thing, because the premeditated thing, because they have to have actual proof of that. And right now they can't even tell us if he was actually in the house or not, or in the neighborhood or not, which we know he wasn't based on the evidence being presented by the people that have seen it and testified thus far. Okay. So I understand that part, because if they really can't claim shit, then they really can't claim premeditated either. Like, they can't claim one, they can't claim the other. Yeah, I agree. Then we have the separation of powers, which is the same argument that they've already done in, I think, like 2 other documents like this. Okay, here we go with this last part. Conclusion. Based upon the foregoing argument to be presented at the hearing hereon, this court is respectfully requested to grant this motion that the utter disregard aggravator in the state's notice pursuant to Idaho Code 184004A be struck. And they do want to talk about it. And they want to talk about it for about 25 minutes, they said. Well, I look tired. I am tired. It's 1:30. Well, it's 1:22. You probably just saw that spit hit the camera. I don't care. It's 1:22 in the morning. I'm tired. It's been 6 hours. 7:22, 8:22, 9:22, 10:22, 11:22, 12:22, 1:22. 6 hours. See, I have to use my fingers to count because I'm so tired. But I'm glad I went through that, because we're supposed to be getting something from the state. Now, it's probably going to be completely sealed. But it's officially 9/6, and it's officially the deadline for state's discovery. Hey guys, I'm cutting in right now because I'm finally at the end of this editing, and I cannot wait to be done with this. This has been some days in the making. This is the longest video I've ever edited, and hopefully will ever have to edit in my life. Anyway, it is now 4:35 p.m. on Saturday, September the 7th, and we do not have anything additional on the public case of interest website. I just checked. The document that I just read you guys is the last one that is posted on there. So nothing from the state having to file their discovery for the deadline of yesterday, the 6th, has been posted. It doesn't show anything in the case summary either, which normally, if something is filed or placed in the filing for the public website, it'll show up on the summary page about a day or so before it shows up public, and I'm not seeing that either. Again, the defense's filings are the last ones on both the public and the case summary page. Now, I know some of you guys have heard the rumors that apparently Judge has granted the change of venue. I heard about it first from JLR posting something about it on Twitter. I ran over to Facebook and saw the Goncalves family's Facebook page post. I have all of that in a community post for you guys to go and take a look at if you haven't seen it. But the Goncalves family post doesn't actually specify anything about the change of venue being granted. JLR, Forensic Frenzy, all these other social media, TikToker, YouTuber people, okay, they're out here saying, oh, I get first scoop. Oh, I got inside info. No, you're just on Steve Goncalves' very, very long, irrelevant email list, because he sends it to people with 100,000 subscribers and 5 subscribers. Steve just sends stuff all willy-nilly to everybody. So it's the big-headedness of some of these people acting like they got inside information is honestly so hilarious to me, because it's not important. You're not special is what I'm getting at with that. Anyway, there's nothing public about that either. If it is true, which I highly doubt that it's not, because it's an official document and it's going to come out anyway, and the source is the Goncalveses from what I'm seeing, and I doubt they're going to be out here throwing a little bit of a fit on Facebook if they got their way and it was staying in Latah County. So I'm not saying that I don't believe it's factual. I just don't like whenever information comes out without documentational proof, and I have yet to see it from anybody claiming to have this so say inside source. It's all just right now hearsay, gossip. That's it. So as soon as the document becomes available, I will be back, and most likely will be live, unless it pops up in the middle of the workday during the week, which is a possibility too because it's the weekend. But I am keeping an eye out. Trust me. But if you've made it this far, if you have made it this frickin' far, kudos to you. Pat yourself on the back, give yourself a hug, and go treat yourself, because this was insane. Insane. But I want to know what you guys think about it down in the comments. Some of you might not agree with my arguments. But again, I will double down that regardless of how I feel about what they're actually proving or not proving against Bryan, I do not agree freaking ever that they are sitting here trying to downgrade the severity of what happened here for their arguments. That shit ain't cute. It's just not cute at all. If you like the way that I present this information and give my opinion, please not forget to leave a like on your way out. Subscribe to the channel if you are not subscribed already. And don't forget to make sure that your notification bell is set to all so you don't miss any of my rants, reactions, reviews, updates, or deep dives. See y'all.